you are coming with me.
This is mens rea in 60 seconds. That mean judge in Legally Blonde didn't need mens rea explained, but you might. Every crime has two parts, the bad action, or actus reus, and the bad intent, which is mens rea. Proving someone guilty means proving action and intention, and there are different levels of intent. Did he intend to commit a crime? Was he reckless, or was he negligent? These levels of intent are older than the United States itself, but now laws are being written without a mens rea requirement, meaning a person can be guilty even if she never meant to break the law, or had no idea she was doing something illegal. People have faced large fines and even prison time for things like mislabeling orchids and releasing balloons into the air. One man even got more than 6 years because he didn't know shipping lobsters in plastic bags was a crime. Sorry, I didn't know. Shouldn't become a defense. But we need to consider intent to make sure innocent people don't face prison time. Future laws should take intent into account, and we should use a default level of intent for old laws that don't have a mens rea requirement.
We're here with Mr. Corwin Scott, president of the Evergreen Tacoma Law Club. Now, Mr. Scott, why don't you tell me a little bit about yourself and a little bit about the Law Club and a little bit about the famous expungement clinic?
Well, my name is Corwin Scott, and I'm a junior here at the Evergreen State College. I'm actually going to graduate very soon. I'm a pre-law student. The expungement clinic was created because a lot of the students here who are pre-law students could not find an internship opportunity. So when we couldn't find something, we made an opportunity. We are partnered with the Volunteer Legal Services, who provides attorneys from the Pierce County Bar Association, who come out once a month to assist us in vacation, sealing, or expungement of records. We also hold office hours, which is just the students acting as paralegals, which we are. We help to type up court motions, and we have now started to fill out, or actually to assist in filling out clemency paperwork for people who have crimes or convictions that cannot be sealed or vacated. The clemency is a last-ditch effort to help someone to maintain control or to gain control of their lives. We are doing we are helping as many people as we can. We have a few success stories so far where people have gone down to the Pierce County court and they've had their rights restored. So, in closing, the expungement clinic is a worthwhile effort. All of the members, George Hoyte, Cheryl Bay, Teresa Brown Henderson, Linda Black, and a few others are very dedicated and have worked very hard and diligently to make sure that people receive proper services and people have been helped. We look forward to working with new clients in the future and also partnering with any other organizations in the area to help as many people in our community as we can. Thank you very much, and have a good day.
What number can they call, can people in the community call if they want to be involved with the expungement clinic and have their records expunged, sealed, or destroyed?
Please call me. My name is Corwin Scott. My telephone number is 253-202-3855. From 12 to 12, 24 hours a day. Please feel free to call at any time. I will be more than happy to discuss your case with you and set up an appointment for either office hours or for the next clinic.
Thank you, President Corwin Scott.
Thank you, Mr. Frank.
Tell me, do you know the difference between a black man and a nigger?
The nigger's the one that would even answer that question.
Available Jan 15 at 12 a.m., Jan 23 at 11:59 p.m. 9 days. This assignment was locked Jan 23 at 11:59 p.m. 2. Paralegal staff. From, Supervising Attorney. Re, our client, Puyallup Baseball League, PBL. Our firm has been hired by the Puyallup Baseball League, PBL. The PBL operates a league of 8 baseball teams where people over the age of 18 can play. They use real wooden bats and real baseballs and play every weekend during the regular baseball season, which begins in early April and ends on September 1st. PBL prides itself on playing real baseball instead of softball. Many of the players in the league are former baseball players at the college or semi-professional level and are very skilled. PBL owns and operates 4 baseball fields at their complex. They charge a small admission fee for tickets to the games. Each of the baseball fields has a standard-sized field, concession stands, and seating for up to 1,500 spectators. All of the baseball fields have protective screening nets which protect spectators from being struck by balls or bats that leave the field. These screens extend from first base all the way around the back perimeter of the field, behind home plate, to third base. The screens were installed in 2016 after several incidents in which spectators were injured when they were struck by baseballs or bats that flew into the seating area. These incidents occurred several times each season prior to 2016. No such injuries are known to have occurred after the protective screening was installed. In August of last year, a severe windstorm blew down the protective screen around one of the PBL fields. Because PBL was unable to find a replacement screen on short notice, they decided to proceed with their games as scheduled without the protective screen. 2 days after the netting was destroyed, PBL held a game at the field without the protective nets. During the game, a player hit a baseball into the stands behind home plate. The ball struck a spectator in the eye, causing him severe injuries and the loss of his vision in one eye. PBL believes that they should not have to pay for the injured spectators' damages. Our office has been hired to advise them on whether to attempt a negotiated settlement or to deny the injured spectators' demand for damages. I am in trial this week on another case, and PBL needs a response from me by next week. Because I am unable to research this, I am requesting a memo from you on this issue. Specifically, I need to know if the injured spectator could prove a negligence claim against PBL, and if PBL has any good defenses to the claim. If it looks like plaintiff can prevail, we'll enter into negotiations. If they can't, we'll deny any claims. Please prepare a memo for me in the IRAC format that I can share with PBL when I meet with them next week to advise them on this matter.
George Hoyte, Civil Law, January 23, 2022. Concerning the defense of the Puyallup Baseball League, PBL, against the injured party, plaintiff, in the matter of negligence causing injury. Although there is always an assumption of risk in such a matter as a public event such as a baseball game, where a stray ball or bat has the chance to accidentally strike and injure a spectator, it is this paralegal's understanding through research of this issue, that the injured party, plaintiff, has the ability to prove a case of negligence on the part of the defendant, PBL, and that being the case, the defendant should consider entering into negotiations with the injured party, plaintiff, to rectify this matter justly and swiftly. According to RCW 79A.40.010, safe and adequate facilities and equipment is required for owner and operator. The fact that the PBL prides itself on using real bats and baseballs over softballs, in and of itself is not negligence in its own right. However, the PBL has had prior history of injuring spectators with this hard equipment that they pride themselves in using, in the past. Knowing this, PBL successfully rectified this unfortunate situation with the installation of safety nets, which after its installation, reduced spectator injury rate to 0%. The fact that PBL chose to continue to play their event without safety nets, after the knowledge of their past record of injuring spectators, demonstrates poor lack of judgment at least, and a gross act of negligence at most. However the case, lack of judgment, or gross negligence, PBL is responsible for, yet again, the injury of another spectator. PBL cannot simply now fall back on the assumption of risk defense and hope to prevail in court. In a similar case of Robin Auks, Respondent v. Glens Falls City School District appellant on appeal, the plaintiff lost the case due to the fact that the plaintiff chose to stand in a place that was unprotected when she was struck by a ball and injured. The key word is chose. In the case of PBL, the injured party, plaintiff, did not choose to stand outside the safety net when she was injured. PBL chose to play without the safety net, thus turning an assumption of risk to an expectation of injury less than of which they had a prior history of doing. Poor judgment or gross negligence. In conclusion, PBL will most likely lose this case if it goes to trial. The defense should seek to enter negotiations to settle and remedy the injured party, plaintiff. The argument of assumption of risk is only valid when the spectator understands the risks involved and knows what they are getting into before they get into it. The prior history and foreknowledge of events on the part of PBL has injured yet another spectator due to, again, poor judgment or gross negligence. It is in my opinion in the best interest of the defense to settle this matter and avoid trial, where the judgment will most likely favor the plaintiff.
Hey, homie! Let me see some ID.
All right, man, chill. Here you go.
Figures. Library. Oh, George.
Stop. In Washington State, you do not have to provide identification to a law enforcement officer who approaches you on the street. You don't have to give your driver's license or Washington ID card. You don't have to give out your address, date of birth, or even your name. Now, under certain circumstances, like if you're driving a car, it may be a crime not to provide identification. Consult with an attorney to find out whether or not your situation is one of the exceptions. But generally, you do not have to provide identification. And you want to think, before you reach for that wallet, about whether or not this is going to help or hurt the situation. If you ask the cop whether you're under arrest, and he says yes, he's going to get your ID anyway. It may be better to provide it voluntarily, keep the situation calm. But if you are free to leave, he's going to, if you provide your ID, do a warrants check. It's going to be delay, and delay in this situation is not your friend. As always, whenever you interact with law enforcement, you want to be polite and unhelpful. You want to be honest and silent. Do not do or say anything because the cop wants you to. Do or say things only if it benefits you.
I leave this as a declaration of intent, so no one will be confused. 1. Sic vis pacem parabellum. Latin. The boot camp sergeant made us recite it like a prayer. Sic vis pacem parabellum. If you want peace, prepare for war.
C.R. Taylor Law, P.E.S. 203 4th Avenue East Suite 407. Olympia, Washington 98501. March 9, 2022. To whom it may concern. I am writing concerning George Hoyte. I am an attorney, in practice continuously since 2006. Between 2007 and 2011, I worked with a firm called the Evergreen Law Group, PES, located in Olympia, Washington. I was one of the managing partners of the firm, beginning in 2009. During that time, I represented individuals accused of crimes and represented people who had been the victims of police misconduct in civil, federal litigation. In 2010, the Evergreen Law Group employed George Hoyte as an intern. As one of the managing partners, I had the opportunity to both supervise and work closely with Mr. Hoyte. As I recall, Mr. Hoyte's job duties included both duties along the lines of a legal assistant, answering the telephone, greeting clients, filing legal documents, assisting with organizing the calendar, but also assisting with developing a marketing strategy. In particular, I recall Mr. Hoyte assisting in writing a script for a video advertisement, and actually appeared as an actor in that video. My recollection is that Mr. Hoyte was eager to learn about the interworkings of a criminal defense/police misconduct legal practice, and more than capable of providing a positive contribution. Mr. Hoyte reached out to me recently and indicated he is currently enrolled in a paralegal program at Tacoma Community College. I worked with a graduate of that program in the past and am aware of other attorney colleagues also using that program as a source of office staff. I have no concerns about Mr. Hoyte's ability to complete the program and find work in the legal field upon graduation. Regards, /S/ Christopher Taylor. Christopher Taylor, Attorney at Law. 36035280004, voice, Taylor Law. Com 36057010006, fax.
You have to shoot. If you are logical, you have to shoot.
I do not want to.
What you want is irrelevant. What you've chosen is at hand.
This assignment was locked February 7th at 11:59 p.m. 2. Paralegal staff. From Supervising Attorney J. Rutherford Bicknance. Re. Cunningham v. KURD Radio. Radio station KURD was running a promotion on August 30, 2019. The promotion involved a Kurd disc jockey doing a live mobile broadcast from the radio station's brightly painted van. Throughout the course of the 4-hour broadcast, the Kurd van traveled to various mystery locations in the city and gave away $100 cash prizes to the first listener who could locate the van and repeat a previously broadcast winning password to the Kurd disc jockey in the van. After each on-air award of prize money, the disc jockey would broadcast clues about the next location where listeners could find the Kurd van, and the winning password for the next stop. 18-year-old Evan Ralston was listening to Kurd in his car while searching for the Kurd van. On the third stop of the promotion, Ralston arrived at the secret location shortly after the Kurd van and learned that someone else had already claimed the prize. He decided to follow the van to its next stop and thus be the first to arrive there and claim the prize. Ralston was not the only Kurd listener who had decided to follow the van. Investigators believe that in addition to Ralston, 6 other listener vehicles were following the Kurd van to its 4th location of the promotion. For several miles the listener vehicles jockeyed for position closest to the Kurd van, at times driving dangerously on I-5 through Tacoma. The Kurd van left I-5 at the 56th Street off-ramp. Ralston, attempting to follow the van, collided with a vehicle driven by Janet Cunningham, who was not a Kurd listener and was not aware of the Kurd promotion taking place. The collision forced Ms. Cunningham's vehicle to slam into a guard rail and caused her to sustain life-threatening injuries. Our firm has been hired by Ms. Cunningham to pursue an action against Kurd. A claim against Mr. Ralston is being handled by another attorney. I am handling the case against Kurd. I am in trial on another matter for the rest of this month and do not have time to address this case. I have a meeting with our client next week and I need to be aware of the law of this case. Please prepare an IRAC memo for me which outlines the claims and defenses involved in the case.
George R. Hoyte Intro to Civil Law, March 13, 2022. We are tasked with representing the plaintiff, Mrs. Janet Cunningham, in an action against the radio broadcast station called Curd. We have to prove that by orchestrating a reckless and dangerous radio promotion, that Curd is responsible for the serious physical and mental life-threatening injuries done to her through Curd and their employee disc jockey, Mr. Evan Ralston. To do this, we will explore three avenues to present and rest our case. 1. We must prove that Curd was negligent. 2. We must prove that due to that negligence that Curd is strictly liable. 3. We must prove that due to the fact that their neglect, that disc jockey, Mr. Evan Ralston, was an employee acting in the interest of Curd, we have grounds to argue the case of respondeat superior. Negligence. Negligence is the failure to behave with the level of care that someone of ordinary prudence would have exercised under the same circumstance. The four elements of negligence are duty, breach, cause, and harm. By failing or ignoring to foresee the imminent danger this reckless promotional campaign would cause by influencing reckless drivers, hungry for Curd's prize money, Curd set the stage for a dangerous and unsafe traffic environment that endangered everyone near their employee, Mr. Evan Ralston, and caused life-threatening injuries to Mrs. Cunningham. In short, if Curd wanted to facilitate a promotional campaign such as this, they had a duty to foresee all possible dangers to the public before setting such campaign into motion. By failing to foresee this obvious danger to the public, Curd breached this duty and caused a hornet's nest of reckless drivers who were hungry for Curd's prize money, that directly caused harm to Mrs. Cunningham, who at the time knew nothing of this dangerous promotional campaign, causing direct harm to her person by a car collision. Strict liability. Strict liability exists when a defendant is liable for committing an action, regardless of what his/her intent or mental state was when committing the action. Curd, by facilitating this reckless promotional campaign, is strictly liable for the damages done to the plaintiff Mrs. Cunningham in causing this traffic nightmare in the first place. By failing to foresee the obvious danger of this promotional stunt, Curd and Mr. Evan Ralston are responsible for this unfortunate set of circumstances we have before us now. Respondeat superior. Respondeat superior is the legal doctrine according to which an employer is responsible for the actions of his employers performed during the course of their employment. Mr. Evan Ralston is an employee of Curd, and was acting in the interest of his employer, KURD, during the promotional campaign that caused Mrs. Cunningham her serious, life-threatening injuries. That being the case, the legal doctrine of respondeat superior applies here, holding Curd responsible for the actions of their employee, Mr. Evan Ralston, in this tragic case of negligence and strict liability against Curd. RCW 4.22.015. Fault defined. Fault includes acts or omissions, including misuse of a product, that are in any measure negligent or reckless toward the person or property of the actor or others, or that subject a person to strict tort liability or liability on a product liability claim. The term also includes breach of warranty, unreasonable assumption of risk, and unreasonable failure to avoid an injury or to mitigate damages. Legal requirements of causal relation apply both to fault as the basis for liability and to contributory fault. A comparison of fault for any purpose under RCW 4.22.005 through 4.22.060 shall involve consideration of both the nature of the conduct of the parties to the action and the extent of the causal relation between such conduct and the damages. RCW 4.22.005. Effect of contributory fault. In an action based on fault seeking to recover damages for injury or death to person or harm to property, any contributory fault chargeable to the claimant diminishes proportionately the amount awarded as compensatory damages for an injury attributable to the claimant's contributory fault, but does not bar recovery. This rule applies whether or not under prior law the claimant's contributory fault constituted a defense or was disregarded under applicable legal doctrines, such as last clear chance. Conclusion. According to the law and the preponderance of evidence, I believe that Kurt hasn't had a leg to stand on in court. In short, we and Mrs. Cunningham can take them to the cleaners. Kurt is strictly liable for all damages Mrs. Cunningham has received as a result of this reckless promotional campaign. By failing to foresee the obvious possible dangers, Kurt is in fact negligent and liable for Mrs. Cunningham's injuries. Easy money.
Hey, homie, up against the wall. Turn around, turn around.
Man,
Turn around.
Fuck, I didn't even do nothing, man.
Whatever.
I don't got nothing, dude.
What's this?
What's what?
Oh, shit. What the fuck is this?
Stop. You do not have to consent to a search. Law enforcement asks you if they can search you. You ought to tell them, I do not consent to a search. If they ask you if they can come in your home and search, you should always request to see a search warrant and indicate to them that you are not consenting to a search. They may search anyway. If that happens to you, bear in mind that resisting a police officer can get you hurt and can lead to felony charges. Again, your default position needs to be, I do not consent to a search, I'd like to see a search warrant, and I'm not resisting anything. You need to preserve your rights. If you allow an officer to search you by saying something like, it's okay if you search, I have nothing to hide, go ahead and search, then the officer always has authority to search. And police are very good at finding things and making them look incriminating later on.
When Alexander saw the breadth of his domain, he wept, for there were no more worlds to conquer. Benefits of a classical education.
The Evergreen State College, Tacoma Campus, March 12, 2022. To whom it may concern. From Peter Baccio, J.D., LLM. Regarding George Hoyte, TCC student. George Hoyte, my former student at the Evergreen State College Tacoma campus, has asked me for a letter of support for financial assistance in order to continue in his academic program. I do so gladly. I have had him in an array of classes during his time at the Tacoma campus. I was also his advisor and know his work well. As a student, George was outstanding, gifted, and focused. His questions and comments on issues ranging from law, politics, history, literature, and public policy demonstrated careful preparation for each class discussion. He is a mature, dedicated, and highly focused adult learner. He was a meticulous researcher and a strong writer. He demonstrated sophisticated critical thinking skills. He is capable of analyzing government policies and assessing their impact, especially on our most vulnerable populations. In other areas, he always listened carefully and collaborated very effectively with others, a key in the academic, political, and professional realms. During group project work, he was patient with his fellow students and thoughtful. Other students valued his contributions and enjoyed working with him. In short, he is an empathetic person, concerned about the direction of our nation and the obvious burdens faced by other Americans, especially people in the margins. He is determined to make a difference. He was thriving at the Tacoma campus, working effectively in diverse groups and producing excellent outcomes. I fully support George's goal of procuring enough assistance to complete his academic goals at TCC. He is a talented student with great potential. please feel free to contact me batchup at Evergreen. EDU if you have further questions.
What's up? We're here with Vice President of the Tacoma Evergreen Law Club, Miss Cheryl Bay. How you doing, Miss Bay?
I am doing great, Mr. Hoyte. How are you?
I'm fine, thank you. Why don't you explain to me a little bit about the Tacoma Evergreen Law Club, your position, and what goes on here?
The Evergreen State College Tacoma Law Club is an ongoing club. I don't know how many years there's been one here. However, I became a law club member in 2010, and Warner Campbell was the president. And at that time, we were having an annual, we had some annual things that the law club did. A tenants' rights conference, along with an expungement workshop. This year, under the presidential guidance of Mr. Corwin Scott, our law club has changed the annual expungement workshop into a monthly expungement clinic. The desire of the present law club is to bring hope to the community. And in doing that, we've linked up with Volunteer Legal Services, who is in charge of a kind of the lawyers during their volunteer time, have kind of curved those lawyers into our school and on our campus and made themselves available at an appointed time for the community. And the training for this process was done also by some bar attorneys from Pierce County Bar Association. And the number one thing that I like about that training is they gave us to give to the community hope. They told us that there are many things that on paper said that they can't be expunged, can't be sealed, can't be vacated, but they told us that nothing is impossible. And that's what we try to present to the community that's come into Evergreen to be seen and helped at the law clinic that goes on monthly here, is hope. And we've gone to court with different individuals and having their rights restored, having their felonies sealed after 15, 20 years, after having to work lower than beneath them jobs. They now have a chance to move up in life. They paid their fines, they did their time, they were told if they agreed to, if they pled guilty, their charges would be dismissed, and they weren't. And so the law clinic is an avenue for access to law from people who have no knowledge of what it is they agreed to, and the paperwork looks good to them. We've been blessed to have these attorneys agree to come and assist the public in this way. And we have an excellent group, our club, students that believe in the goals of the Evergreen State College, which are enter to learn and depart to serve, and their willingness to do that on a volunteer basis for the community has been outstanding, and I'm very, very grateful to be a part.
So if someone wants to reach you or reach the Tacoma Evergreen Law Club to set up a time to have their record expunged to speak to an attorney, how can they go about doing that?
They can contact myself by telephone. My number is 253-255-0579.
Thank you very much, Vice President Cheryl Bay of the Tacoma Evergreen Law Club. Thank you for coming on We the Students Television.
Very well. Thank you.
The dreams of youth are the regrets of maturity.
This assignment was locked March 9th at 11:59 p.m. 2. Paralegal staff. From Supervising Attorney Re. Dunn v. Canto. Our client is Robert Canto. About 3 months ago Robert was alone at a bar on a Friday night. There he met a woman named Pamela Dunn. After they got acquainted for a while, Pamela told Robert that she was constantly stressed out because she has lots of credit card debt and the collection agencies were calling her about past repayments. Robert told Pamela not to worry and that he would pay her credit cards off for her. A few days later, Pamela told Robert that she would gather up all her credit card bills and bring them to him. Robert indicated to Pamela that he didn't know what she was talking about and that he would not pay her credit card debt. Yesterday Robert was served with a summons and complaint. Pamela is suing him for breach of contract. It has been many years since I have done a contracts case, so I need you to bring me up to date. Please prepare an interoffice memo for me in the IRAC format. I need to know what Ms. Dunn has to prove in order to make a prima facie case, and if Pamela has any other claims she might bring.
George Hoyte. Intro to Civil Law, March 9, 2022. We are tasked with defending Robert Canto on a breach of contract verbal agreement case. To defend, we have to examine two things. 1. Is there a prima facie standard? 2. Did Mr. Canto agree to and breach a verbal contract with Ms. Dunn, making him liable for damages against her? 1. Prima facie. The meaning of prima facie is based on the first impression accepted as correct until proved otherwise, i.e., an agreement that is sufficient to raise a presumption or establish a fact unless it is rebutted or disproved. First, we must consider the 4 building blocks of any valid contract. 1. Agreement. Mrs. Dunn claims that there was a verbal agreement between her and Mr. Canto for him to pay all of her credit card bills. According to the parole evidence rule, parties' course of dealings refers to a situation where two parties have a history of working together and entering into numerous contracts with each other, and the court can look to the history to clarify or interpret their written expressions. In this case, Mr. Canto and Ms. Dunn made this alleged agreement the same night they met at a bar. That being the case, there is no prior history between the two to rely on the parole evidence rule. 2. Consideration. Something of value must be given by both parties. In this case, Ms. Dunn claims that Mr. Canto agreed to pay all of her credit card bills. However, there is no statement of anything being received by Mr. Canto in return for this generosity. Although Ms. Dunn is free to make as bad a deal as she wants, if this can be considered a deal and not a gift, I think the fact that they have no history and met at a bar when said deal was made is enough for the court to void the contract for unconscionably. This remedy is found where this verbal contract would shock the conscience of the court, not only due to the fact that Mr. Canto seemingly receives nothing in return for this alleged verbal deal, with no parole evidence, but the fact of the environment itself where this alleged verbal deal took place. This leads us to the 3rd building block of a contract. 3. Capacity. The fact of the matter is that this deal took place at a bar, meaning alcoholic beverages were being served. If Mr. Canto was intoxicated, under the influence of alcohol, this in of itself means he lacked the capacity to enter into a binding contract at all under these circumstances. 4. Legality. From the tearing down of the first 3 building blocks of a binding contract thus far, I see no legality in it. I question whether there are clean hands in this case at all. It may not necessarily cross the line of illegal, but it definitely treads the line of unethically taking advantage of an intoxicated person through questionable negotiations. RCW 19.36.110. Enforceability of credit agreements, effect of oral agreements, and partial performance. A credit agreement is not enforceable against the creditor unless the agreement is in writing and signed by the creditor. The rights and obligations of the parties to a credit agreement shall be determined solely from the written agreement, and any prior or contemporaneous oral agreements between the parties are superseded by, merged into, and may not vary the credit agreement. Partial performance of a credit agreement does not remove the agreement from the operation of this section. In conclusion, Ms. Dunn has no written agreement with Mr. Canto that would validate this verbal contract anyway due to RCW 19.36.110. In short, Ms. Dunn doesn't have a leg to stand on in court. Not only does her claim of a verbal contract not meet the building blocks of a binding agreement, consideration, or capacity, it also questions the legality itself since the RCW 19.36.110 require a credit agreement in order to be enforceable against the creditor, to be signed in writing and signed by the creditor, not verbally. IT's the law. Unfortunately for Ms. Dunn, she apparently out-hustled herself, and the best hustler won. She has no case. Tell her to beat it. Note: contributory negligence. Joke: sorry, couldn't resist.
We're going to be proctoring an exam this morning, and then both of us will be back this afternoon after lunch. And you get your results and more information about the LSAT and the law school admissions process and how all of that works. So we're going to be doing all of that today. In other words, Jessica will be here with you all day today. Before we get started with the formal instructions for the exam, some things that you should know. We're about to complete a 5-section full-length LSAT exam. We're going to do all of the multiple choice sections. The exam that you're going to take differs from test day in that we are not going to complete a writing sample today. That is always the last section of the exam, it's section 6, and it is unscored. And they always ask us not to administer the writing exam today because it won't be scored. We're happy to comply with that. It makes your time a little bit shorter on the exam. So we're going to complete the 5 multiple choice sections today. The test you're going to take today is Prep Test 36. This is the December 2001 LSAT exam. So this is proximate, or next to, the best LSAT exam. Prep Test 35. Anybody know why that one's the best? For a totally personal reason. It is right after 9/11, that's true. The most closely administered. That was my LSAT. The one that I took. So that one's my favorite. It got me into law school at the University of Michigan. So you're going to be doing Prep Test 36. It's pretty good, but not the best. So we're going to take that exam today. We're going to, while you're having lunch, we are going to score the exams for you, so you're going to get your results back right after the test today. Some strategic things for you to know. The test booklets are for you to keep. So you're going to take that with you, and that will also mean, just like on test day, you get to write in the test booklet while you take the exam. So you should feel free to write all over that. You're going to take that with you. The only thing we're going to take from you is your grid, so that we can get that scanned. So everything else is for you too. Another strategic point, some of you may or may not know, but on the LSAT, there is no penalty for wrong answers. So if you don't know the answer to a question, or if you're short on time, it is in your best interest for your score simply to guess. You can't lose points for wrong answers on the exam, unlike notoriously the SAT, where there's a penalty for wrong answers. This test does not work that way. So if you don't know, or if you're short on time, it's better to guess than to leave it blank. You can't lose points on the exam. You can only fail to gain them. So those are a couple strategic points for you to know. I have some formal proctoring instructions that we're going to read through, talk about the structure of the exam and how all of that works. Any general question about the 3 hours and 10 minutes of fun time that we're about to have? Where we could go? Yes, sir. What's that? Only presumably. Only if you'd be looking at somebody else's bill list. If you have their permission, then you can probably form a small travel to your heart's content. Yeah. However that works for you. What I would recommend is that you treat the exam as best of a testing simulation as you can, because I think that'll help everybody else get as much out of the exam as they can. So, that said, I'm going to go ahead and start the formal proctoring instructions. The one thing that you do need to know that I'm about to leave you again, and that's important, is that on LSAT test day, you can't have any food or anything else with you. Again, today, like earlier, I'm not particularly concerned about that, but I'm tempted it would be really big about that. You didn't have any coffee or water or anything else with you. Today, I don't care. Just be careful not to spill it on your grid, because that will make it very difficult to scan. So that's my answer. Yes, sir.
Does any of this information pass on to any other organizations other than CAC?
No. So Clio is one of our national partners. We do this event with them everywhere that they organize it around the country. So this information doesn't go to anybody else. Yeah. True story. Thank you for asking. Yeah. Those entities, you're usually talking about something that is based on that whole some versus most. For example, some means one or more. Most means what? Majority, that's correct. And the LSAT will test you on your ability to recognize the difference between some and most. Can versus must. Can means it's possible. Must means has. That's the kind of thing that you want to train yourself to notice. Okay? The LSAT loves those kinds of words. Okay? And I guess I love the LSAT, so therefore I love those kinds of words. I guess that's how you can formal logic that. Okay. So anyway, so let's look at one more example for number 5 and use our method again. We wouldn't use this because this is our previous work. So let's go ahead and redraw our list of entities. And let's take a look here at our if then. If watermelons. So yes on watermelons. Great. What does that mean? We have to have what? Oranges. Figs or tangerines or both. So we have to have at least one of figs or tangerines. Okay? Kind of a loose rule. We don't have really any certainties. We can't circle anything else. But we know we have to at least have one. Of figs and tangerines. Right? Everything else still would be the same rules, and we're not sure about it. Okay? So let's take a look at must be false. The stand does not carry figs. Does the stand have to carry figs in this case? No, because it has to carry at least one. So it could carry tangerines and not figs. Same thing with B. The stand does not carry tangerines. That's not a must be false because, again, it could be at least one. Okay, everybody cool so far?
Yeah.
Great. Okay, the stand does not carry pears. Do we see that as being necessary? No? Okay. That doesn't seem to help. The stand carries pears, but not oranges. Where would we want to make sure to go here? We want to go back to what?
Chart.
Yeah, to our chart, exactly. So yes on pears and no on oranges. Is that okay? Can you be in New York but not in Manhattan? Is that okay?
Yeah.
Yes. Excellent. Okay. The stand carries pears but not tangerines. Uh-oh. Is that a problem? Yes on pears would mean what? Yes on tangerines. So do we have our must be false? We do. Okay. Yeah. Huh? Okay. Sure. The stand does not carry pears. Well, here's the thing. If it didn't carry pears for sure,
then we would have been given a rule that completely eliminates pairs. So, for example, we would have pairs X'd out here if we did that. Since all we're doing is yes on watermelons, pairs aren't effective. So they are possible, but not definite. So we can't say it must be false if you don't carry pairs. It could be true. Okay? All right. Any other questions?
I guess it's going off that. Is it because you have watermelons and we know, like, sometimes if you have watermelons, you may have oranges, which means you may have pears too? Or
it's a little bit, it's more just a matter of you don't want to overanalyze the remainder of the sketch, the part that's not being affected. The only thing that we can say is true on the basis of watermelons is one of these. At least one of these. That's all we can say is true. So the thing is that yes on watermelons does not affect oranges, because oranges still could exist, because we saw last time no on watermelons meant no on oranges. Yes on watermelons means maybe oranges. So the fact that you have all these maybes is the kind of thing that you want to look at maybes, but you're looking for a must-be, right? So you have all these maybes, and you're looking for a must-be. Maybes are not a must-be. So that's why E would be correct, because E directly contradicts your sketch. It says, yes on pears, no on tangerines. Can't do it. Okay? But all the rest of them are possible. And what we want to learn to do is not have to go into all of the possibilities, but then just basically say, well, I don't have for certain on this. In my list, I have not crossed out pears, I have not circled oranges, so all of those things are still possible.
I have two.
Sure.
The first one is, so for the T, didn't we do that, the converse thing, where it's like no tangerines, we have kiwis, so then it wouldn't really contradict our sketch, because then we still have...
Well, here's the thing. It says, has pears, but not tangerines. Okay? Yes on pears means what? No on kiwis. Yes on tangerines. That's why it contradicts it.
So then why don't we write that right there? The question back to you, what must be false?
Yeah, what must be false? So I'm not sure. What was your question?
Well, we can see what we did before we even drew the rules. We did we did the second rule, which was no tangerines.
Sure.
So right there it says no tangerines, and we have kiwis. So it says we have no tangerines.
So okay, so here's the thing though that we want to actually be concerned with. On answer choice E, it says the stand carries pairs. Yes, pairs, according to that, right? Answer choice E. Yes, pairs. So what we want to do is use our chart to see what yes pairs tells us. Yes on pears tells us no on kiwis, tells us yes on tangerines.
Okay, so you don't want to go back to the old...
No. The reason why this is good to focus on is because if we try to link everything every time we had an answer choice like this, that'd be a lot of extra work. We already have them linked up, and we can say yes on pears means everything to the right. Then we know that yes on pears and no on tangerines is not possible based on our sketch.
Logic.
Yeah.
You could not live with your own failure. Where did that bring you? Back to me.
Harold G. Moss. Council Member, District No. 4. December 16, 1998. To whom it may concern. I am writing this letter on behalf of Mr. George Hoyte, a young man that I have come to know and admire over the past 4 to 5 years. I met Mr. Hoyte during the time I served on the Tacoma City Council and as mayor of the city. Mr. Hoyte was chosen to represent the city's youth in Tacoma's Empowerment Zone application in 1994. During this time, Mr. Hoyte, along with city staff, community representatives, Congressman Norm Dix and I traveled to Washington, D.C. to make the formal presentation of our application directly to Henry Cisneros, Secretary, Department of Housing and Urban Development. It was during that time I noticed George's rare gift for negotiation. He spoke with the Secretary confidently, listened and demonstrated a patience far beyond his years. The secretary confidently listened and remarked about his presentation and depth of knowledge of what young people could expect from being included in the application. George continues to be active in the community. His participation has centered on his interest and skills in media projects. He's an excellent interviewer who possesses a real sense of depth and asks insightful questions. He is also involved with Strive, a youth-sponsored television program that focuses on involving young people in the direct hands-on experience of video production. I am particularly pleased with his production called Jones in the Speed Zone. The show, which was created as a result of a vision George had, is aimed at educating young people on how to deal with the issues they face. The show hopes to impact young people by showcasing their peers handling negative situations in positive ways. It is using the old adage, if you give a man a fish, he can eat for a day, but if you teach a man to fish, he can eat for a lifetime. I take great pride in recommending him to you as a dedicated young man whom I have a lot of faith in and who has a bright future ahead of him. Should you have additional questions or would like further information, please feel free to contact me at 253-798-7590. Sincerely, Harold G. Moss, Council Member, District 4.
South, my community. Come to unity. A collective state is where you should be. Understanding all the differences of all people, no matter where they live. It's essential for us to prevail. Otherwise, the whole world will fail. Stop separating, start communicating. Then you reach the point of relating to one another. My brother, the time is now in order to recover.
Hello. I'm George Hoyte. I'm here as the spokesperson for the youth and young adult of Tacoma, Washington. I'm here to ask for your support in making Tacoma a federal empowerment zone.
We often hear that our youth are our nation's greatest resource. We agree. This is our opportunity to become productive citizens and responsible taxpayers, to manage our country in the future.
We need to be empowered now. We need to prepare for the jobs of tomorrow, jobs that haven't even been created yet. We have gotten to the on-ramp of the information highway through our own efforts. We got here by actual hands-on experience and exploration in the community through television and video programming. We need the tools now to get to the superhighway.
Hi, I'm Kinsey. I'm 15 and attended Wilson High School. One of our most important tools is the clipboard. Everything starts here. It's where we write down our thoughts, start storyboards, and scripts. Most important, the clipboard can take you anywhere if you know how to present yourself. A simple but powerful tool in our kit for the 21st century.
Hi, I'm Vital, now 14 years old. I'm starting high school at Stadium. This old camera lets me tell a story. I can make a difference and help other youth with it. I can show adults how kids see things and help with understanding. It is a visual tool for the information age.
My name's Samantha Stetter. I'm 17 years old and I'm working on my GED. This microphone is my power. With it I can communicate and do anything I want to in this world. In a recent Street Beat newsletter, we showed two kids that were talking. One kid said, "How do you shoot this?" And the other kid said, "You don't. You communicate with it." Communication is one answer to the violence that our country faces. We need these tools to help.
I'm Travis D. Lattimore. I'm 18, a senior at Wilson High School. Headphones. They help me keep track of how our interview is going, check out any sound and any technical trouble, and make sure all things are going well. Headphones. Simple, but necessary. One of the tools we need for the information age.
Hi, I'm Keisha Baker. I'm 17 years old and I attend Wilson High School. This computer is our vehicle's information to the superhighway. You can go anywhere around the world with it. We need to create a youth and a young adult Network in Tacoma. We need your help. Hi, I'm Danielle. I'm 16 and I'm a Wilson High School student. This is the edit bay at Stripe. For me, it all happens here, behind the scenes. This experience is my ticket into the next century, our century, and we need your help to do it right.
My name is Damon Brown, and I'm going to create my own job, satellite dishes. From here, we can travel almost anywhere in the world. We can communicate with other youth. We can share our concerns, talents, and ideas. Maybe one day we can find out that we're not so different from one another. We need these tools, this technology. The 21st century belongs to us. Help us prepare for it.
Many of these youth will be 21 at the turn of the century. Help us obtain the tools, the skills, and the guidance to flourish. If they succeed, our country will. We need your support.
Yes!
Back the future for you. Support the Tacoma Empowerment Zone.
Ya, para sazonar tu vida, latinos, amigas y amigos, escuche las palabras que te digo, y lo estoy diciendo en español, porque tengo salsa y control.
I could have killed them all. I could have killed you. In town, you're the law. Out here, it's me. Don't push it. Don't push it, or I'll give you a war you won't believe. Let it go. Let it go.
This assignment was locked February 23 at 11:59 p.m. 2. Paralegal staff. From, Supervising Attorney. Re, Churlish v. West Industries. Our firm has a new client, West Industries. West manufactures and installs water filtration systems for large building projects and agricultural facilities. On June 22, 2021, a West employee named David Ferris was returning to the West main office in a company-owned vehicle when he stopped at a restaurant for lunch. As Mr. Ferris entered the parking area, a car driven by Sandra Churlish approached and blocked his path. Ms. Churlish and Mr. Ferris had been involved in a dating relationship for 2 years, and on that morning, Mr. Ferris had called Ms. Churlish and told her that he no longer wanted to see her. Ms. Churlish was very upset. As Ferris tried to back his vehicle away, Churlish got out of her car and approached Ferris's vehicle on foot. Ferris locked the doors and rolled down his side window a couple of inches. A heated argument took place with Churlish at the side of Ferris's vehicle. Ms. Churlish picked up a rock and smashed the window of Ferris's truck. The argument continued for another 5 minutes. Ferris attempted to drive around Ms. Churlish's parked vehicle and leave the scene, but in doing so he struck Ms. Churlish with his truck and caused her to be seriously injured. Ms. Churlish is suing Mr. Ferris and West Industries for negligence. We represent West Industries. Mr. Ferris has hired his own attorney to defend the claim against him. I am very busy for the next week and will be out of town the following week. I have not had time to research the case and formulate a defense to this action. Please prepare a memo in the IRAC format for me which addresses what claims Ms. Churlish may have and what defenses are available to West Industries, if any.
George R. Hoyte Introduction to Civil Law, February 23, 2022. Churlish v. West Industries. Issue: Are West Industries responsible for Sandra Churlish's injuries caused by employee David Ferris and company car during employment hours? Is there a case for respondeat superior through joint and several liabilities? Rule: RCW 51.08.013. Acting in the course of employment. 1. Acting in the course of employment means the worker acting at his or her employer's direction or in the furtherance of his or her employer's business, which shall include time spent going to and from work on the job site, as defined in RCW 51.32.015 and 51.36.040, insofar as such time is immediate to the actual time that the worker is engaged in the work process in areas controlled by his or her employer, except parking area. It is not necessary that at the time an injury is sustained by a worker he or she is doing the work on which his or her compensation is based, or that the event is within the time limits on which industrial insurance or medical aid premiums or assessments are paid. RCW 51.32.015. Time and place of coverage, lunch period. The benefits of Title 51 RCW shall be provided to each worker receiving an injury, as defined therein, during the course of his or her employment and also during his or her lunch period as established by the employer while on the job site. The job site shall consist of the premises as are occupied, used or contracted for by the employer for the business or work process in which the employer is then engaged, provided that if a worker by reason of his or her employment leaves such job site under the direction, control or request of the employer, and if such worker is injured during his or her lunch period while so away from the job site, the worker shall receive the benefits as provided herein, and provided further, that the employer need not consider the lunch period in his or her payroll for the purpose of reporting to the department unless the worker is actually paid for such period of time. Analysis: we cannot place the blame on David Ferris using the frolic argument, due to the fact that this happened during a lunch break, which is seen as a detour. However, in breaking down the elements for the case of respondeat superior: 1. This act was not authorized by the employer. 2. The time, place, and purpose did not benefit the employer. 3. Unusual circumstances. 4. It did not advance the employer's interest. Employer wasn't aware of who Sandra Churlish was. 5. It was a personal matter of the employee. 6. Yes. It was a company car. However, all legal requirements met. 7. The employer had no reason to know the employee would act in such matter, nor be placed in such an unusual circumstance. Conclusion: although on the surface, the law seems to favor the plaintiff, the fact that she fails to meet the 7 elements to make the case of respondeat superior in this set of unusual circumstances, leaves me with one logical argument for our defense. Contributory negligence. In boxing in the company vehicle, Davy Ferris, and damaging the vehicle with violence, whichever way Mr. Ferris chose to remove himself from this potentially life-threatening situation calls many uncontrollable and unforeseeable factors into question. However, one factor is constant. In this personal matter, Sandra Churlish acted recklessly and maybe illegally when confronting employee Davis Ferris. This situation was not authorized, nor foreseen by West Industries. It was a personal matter of the heart and a crime of passion on the part of Sandra Churlish. Recommendation: offer a meager settlement. If it is refused, see her in court. Countersue for the damaged company vehicle and reckless endangerment. Contributory negligence. It was her own damn fault.
Hey homeboy, let me help you. Where'd you get the weed from?
Hey man, ain't even my jacket, dude. I don't know where that came from. It's my homeboy's jacket, dude. We were just out the street, man. I lost my coat. You let me, yo, man, for real. For real, I don't know where it came from, man. You know what I'm saying? Hey, you could have to my...
Stop. Shut the fuck up. You do not have to answer questions, and you shouldn't. Especially after you've been read your Miranda rights. Because if you've been read your Miranda rights, that means you are under arrest. You are not talking your way out of anything. And everything you say is going to get twisted by the cops and used against you later. Your silence cannot be legally twisted to mean anything. There is no benefit for you talking, and it's only going to hurt you. So don't say anything. When a cop asks you questions, you say, I do not want to speak to you. I do not want to answer questions. I want to remain silent, and I want a lawyer. as always, whenever you interact with law enforcement, you want to be polite and unhelpful. You want to be honest and you want to be silent. Don't say or do anything just because a cop asks you to. Say or do something because it benefits you.
There are two types of vice presidents, doormats and matadors. Which do you think I intend to be?
March 21, 2022. To whom it may concern. RE. Reference for George Hoyte. Please accept this letter of reference and recommendation for Mr. Hoyte, whom I have known since he was my high school student during the early 1990s and throughout the time since then. I have no reservations whatsoever in my support for this young man whose brilliance and capabilities have, unfortunately, been obscured and untapped by the circumstances of his life for much of his young adulthood. Mr. Hoyte has a keen intellect, a love of knowledge and a strong work ethic, the likes of which I truly have not seen many times in my 35+ years as an educator. Beyond that, he has a deep and abiding love of humanity and strives always, in his personal and professional life, to work for truth, equality and justice for all. As the only child of his invalid mother, Mr. Hoyte's launch into the fullness of his potential has been postponed for nearly 20 years because he cared for his mother, for the past 7 years, full-time. Since his mother's recent passing, he has been working, with support from Employment Security, Workforce Education Services Tacoma Community College and staff and faculty who know him, to complete a paralegal studies degree. Mr. Hoyte has aspired to be a lawyer for as long as I've known him, and he is finally in a place where he can begin to realize a career in the legal profession. Right now, he is facing yet another hurdle. After applying for unemployment and beginning studies under the Worker Retraining Grant Program, he was informed by Employment Security that he wouldn't qualify for training benefits because paralegal is not currently in demand. It happens that one of my professional roles for over 5 years was as Worker Retraining Specialist, and so I have been also assisting him with advice on appealing this decision. I have no doubt that Mr. Hoyte, given the chance to complete his paralegal degree while continuing to collect his unemployment, will be very successful in his legal career. He is a fine young man with drive and determination and is exactly the kind of person we want in our legal profession. Thank you for your consideration. Sincerely. Lori Arnold, M.Ed. Independent Consultant. clarityinc@gmail.com.
Well, now I'd like to introduce Evan Marquis, who is a trustee of the Young Lawyers section, who's going to present the Liberty Bell Awards to the non-lawyer recipient. And this year, as you'll become apparent in a moment, we decided to give 2 awards out to non-lawyers. So here's Evan.
Pardon my lingering cough. Hopefully I won't cough too much up here, but I was a bit sick the last week, so hopefully that doesn't come up today. Ladies and gentlemen, it gives me great pride to be here today as a representative of the Pierce County Bar Association and the Young Lawyers section, and to present this year's award, the Liberty Bell Award, to our co-non-lawyer recipients. As we've mentioned at this lunch today, this year's Law Day theme is the legacy of John Adams from Boston to Guantanamo, with the idea of celebrating both lawyers and non-lawyers who represent the accused, even when doing so may not be the most popular decision. In light of this theme, it is particularly appropriate that our co-non-lawyer honorees have spent the last 6 months developing and growing a volunteer legal clinic in Pierce County designed to help individuals expunge the criminal records of individuals who cannot afford legal services. Today, expungement is particularly important to the qualified individuals because of the advancement in technology that have made public records more available and accessible to potential employers and landlords. With the job and rental housing markets being as competitive as they are, a minor conviction in someone's distant past should not impact their current employability and housing options. The Expungement Clinic seeks to help those qualified individuals take the final step in the criminal rehabilitation process and move on with their lives. Since its inception in December 2010, the Volunteer Legal Services Expungement Clinic has assisted 115 individuals in expunging their record, and yet has an unending list of future clients. I promised I would give a plug today for Volunteer Legal Services Expungement Clinic. So for those of you who are looking for volunteer options and an opportunity to use your legal skills, please consider volunteering with Volunteer Legal Services and the Expungement Clinic, as there is an insatiable demand for legal services for those who can't afford it in our community. Now on to our co-recipients. Our first co-recipient is Linda Black. Linda Black's involvement in the legal profession is a second career for her. She has an associate's degree in business management from TCC and initially worked for a number of years as a loan officer. When she decided that wasn't for her, went back to school at TCC to obtain a paralegal's degree. During school, she interned at Northwest Justice Project and then was hired on full-time after graduating to the Pierce County Volunteer Legal Services, where she's been for the last 2 years. She is exceptionally passionate about working with clients, and she made that very clear to me when we spoke. And she enjoys investigating the facts involving the clients. Her responsibilities at Volunteer Legal Services include recruiting volunteer attorneys. So for those of you who are interested, get your business cards to Linda before you leave. And also screening potential clients to determine what appropriate clinic is available for their needs. Our other co-recipient is Corwin Black, and he is currently pursuing his bachelor's degree in liberal arts with an emphasis in law at Evergreen State College.
That's Corwin Scott.
Scott. Linda Black, Corwin Scott. Yes, I apologize. Corwin Scott, thank you very much. He is currently the president of the Law Club and is scheduled to graduate in June this year. Afterwards, he plans to continue his education and ultimately attend law school and obtain a law degree. He's the proud father of 3 and is born and raised in Tacoma. The genesis of the Expungement Clinic is the after-school parking lot at Evergreen State College, where Linda and Corwin would discuss the needs of our community and the available resources at their disposal. Corwin was able to mobilize the available resources at Evergreen with the support of the college's director, including the facilities, student interns, and the technology to support the clinic. Linda was able to bring in, with the support of Volunteer Legal Services and Lori Davenport, legal manpower, and some grant money to help get this clinic up and running. With those pieces in place, they have been able to establish a monthly clinic and a resource center staffed by students at Evergreen State College. With their relentless commitment to helping our community, they truly encompass what we are here to celebrate today. Please help me congratulating the 2011 non-lawyer recipients of the Liberty Bell Award, Linda Black and Corwin Scott. I'll invite them to make a few comments if they would like.
You know, it's been so exciting how successful the clinics have been and all the great people that have helped us. The students in the law club that facilitate the clinics. We have 20 attorneys that have actively participated. Some of them are here. And it's just been great because of all the people. And I guess Corwin and I kind of forgot about those meetings after class in the parking lot in the rain when this was all a dream, and we kind of forgot about our part. So thank you for remembering us for it.
Well, I would like to say thank you for recognizing Ms. Black and I. Have come a long way in a very short time. We've done a lot of work together. I also would like to recognize the Evergreen State College for giving us the opportunity to put together the clinic. I first would like to say thank you to Dr. R.T. Young, to attorney Barbara Laners, to my mother Kitty Scott, and my father Elwood Scott, to the people who have been in the trenches in the office hours and in every clinic. Mr. George Hoyte, who's holding the camera, to Teresa Henderson Brown, and to Mrs. Cheryl Day. I also would like to thank the fellow students, and I also would like to thank the attorneys for coming out each and every clinic. It's because of you that I'm standing here today. And also to Ms. Davenport as well. She's been my hero. Thank you very much and have a good day.
They have taught man that he is a hopeless misfit, made of two elements, both symbols of death. A body without a soul is a corpse. A soul without a body is a ghost. Yet such is their image of man's nature, the battleground of a struggle between a corpse and a ghost. A corpse endowed with some evil volition of its own, and a ghost endowed with the knowledge that everything known to man is non-existent, that only the unknowable exists. Do you observe what human faculty that doctrine was designed to ignore? It was man's mind that had to be negated in order to make him fall apart. Once he surrendered reason, he was left at the mercy of two monsters whom he could not fathom or control.
Walthers v. Abbott. Due April 21st by 11:59 p.m. Points 200 submitting a file upload available April 11th at 12 a.m., April 21st at 11:59 p.m. 11 days. This assignment was locked April 21st at 11:59 p.m. In this assignment our office has been hired to pursue a case for our client Mr. Walthers. He was injured in a rear-end collision on May 12, 2015. Ignore our statute of limitations problem, the negotiations with the defense have broken down, so we need to file a complaint. Please draft a complaint for negligence. Here's the accident report. Note that the diagram appears to be inaccurate. To check on what the little numbers in the margins of the police report are, you'll need to do a little online detective work and find the WSB collision report overlay. Links to an external site. If you need one, create a new pleading with Microsoft Office, or you can use this pleading paper template to draft your complaint. Be sure to double space your complaint. All court documents should always be double spaced and on numbered pleading paper like the template. The entire document should be in Times New Roman 12. Some of the complaints we've looked at in class may be helpful to you. Reviewing your class notes and the model complaints we looked at in the Week 3 summary, available at the end of this week, you will remember some of the things from these complaints that we liked and what we didn't. Use what we liked, lose what we didn't. On the template there are places where some of our case information belongs. Make sure we're in the right county and court. Put in our information and remove any irrelevant material. Remember to include all the necessary parts of a complaint: jurisdiction, elements, the damages we're trying for. They may include lost wages, medical bills, future earnings, pain and suffering, etc. Put in all the damages we can reasonably request. Do not add facts that we don't have. Use your own name as the attorney, and the case number will be 22-29496-5. The grading will depend in large part on precisely you follow instructions and on how professional the document looks. That means that formatting, spelling and grammar errors will cost you points. Think about what you borrow from model complaints before you borrow it. The supervising attorney needs this to be done right the first time, because supervising attorneys hate paying you for making mistakes that they have to pay you to fix, and there is usually no time to fix them. Questions? Email me or bring your questions to class next week.
George R. Armorer, assignment in the District of the State of Washington in and for the County of Thurston. Nicholas C. Walters plaintiff, versus Mark A. Abbott and J. Doe Abbott, individually and as marital community defendants. Case number 22-29496-5, complaint for damages. I. Parties 1.1. Plaintiff Nicholas C. Walters is currently a resident of Bonnie Lake, Pierce County, Washington, at all times relevant and material to this complaint. Pleading title: 2.1.2. Defendants, Mark A. Abbott and J. Doe Abbott, on information and belief, are residents of Rainier, Thurston County, Washington, at all times relevant and material to this complaint. 1.3. Passenger, Chelsea R. Lemberg, is currently a resident of Puyallup, Pierce County, Washington, at all times relevant and material to this complaint. 2. Jurisdiction and venue. 2.1. This court has jurisdiction over the subject matter and the parties involved, and is the proper venue for this proceeding pursuant to RCW 4.12.025. 3. Statement of Facts 3.1. On the date of May 12, 2015, at 17:08, Nicholas C. Walters and passenger Chelsea R. Lemberg were driving on NB Interstate 5. 3.2. Defendant Abbott, who was tailgating behind plaintiff Walters, failed to stop in time when plaintiff Walters slowed his vehicle in concordance with traffic ahead. 3.3. Defendant Abbott crashed into the back of the plaintiff Walters' vehicle, damaging the rear end of the plaintiff's vehicle, and injuring both the plaintiff Walter and his pleading title, 3. Passenger Chelsea R. Lemberg, who both cited neck pain caused by the accident. 4. Negligence. 4.1. Duty. The defendant, through common law, statutes, regulation, and/or ordinance, owed the plaintiff a duty to drive attentively, keeping careful lookout, and otherwise exercise ordinary and reasonable care while operating a vehicle within the state of Washington. This duty included a duty to obey all relevant rules of the road pursuant to RCW 46.61.145. 4.2. Breach. The defendant breached their duties as set forth in 4.3. Proximate cause, as a direct and proximate cause of the defendant's negligent actions, which breached the duty observed in RCW 46.61.145, the plaintiff Walters and his passenger, Lemberg, has suffered from neck pain, emotional distress, other pending medical expenditures, and damages to the vehicle. V. Prayer of Relief 5.1 Special damages for plaintiff in such amounts as are proven at trial. Pleading Title 4.5.2 General damages for plaintiff in such amounts as are proven at trial. 5.3 Costs including reasonable attorney's fees for plaintiff as are proven at trial. 5.4 For such other and further relief as the court deems just, equitable and proper for plaintiff at time of trial. Dated this 21 day of April 2022. George R. Hoyte, attorney for plaintiff.
Great, Mr. Paul Landry. The formatting is off, George. It looks odd. 1.3, we don't represent the passenger. Fix those things and this one will work.
Your teachers, the mystics of both schools, have reversed causality in their consciousness, then strive to reverse it in existence. They take their emotions as a cause and their mind as a passive effect. They make their emotions their tool for perceiving reality. They hold their desires as an irreducible primary, as a fact, superseding all facts. An honest man does not desire until he has identified the object of his desire. He says, "It is, therefore I want it." They say, "I want it, therefore it is." They want to cheat the axiom of existence and consciousness. They want their consciousness to be an instrument not of perceiving, but of creating existence, and existence to be not the object, but the subject of their consciousness. They want to be that God they created in their image and likeness, who creates a universe out of a void by means of an arbitrary whim.
George R. Hoyte's resume. Serve a notice at gmail.com. Paralegal student / barber / bartender / professional performer. Accomplishments. Co-author and published book, The Obia Woman, by Anastasia Armour, available at Amazon.com. 2018 spokesman for the Empowerment Zone team in 1993. Traveled to Washington, D.C. with Tacoma. Mayor Harold Moss, Freight House Square owner Keith Stone, and others. Met with the Secretary of HUD. Henry Cisneros and other delegates contributed to earning $2 million for the city of Tacoma. Articles and pictures are published in the News Tribune and Facebook. Performed at the Tacoma Dome twice for the Dr. Martin Luther King Jr. birthday celebration in 2009 and 2010 with Drive John Falskow, Dean of Tacoma Community College / conductor, Seattle Symphony. Together, we formed a group, Serve I Notice and Theory. We have recorded and released multiple albums, and have done college tours around Tacoma and Seattle, WA. Another member of our group is Sam Caviezel, Beethoven, is a current clarinet player for the Philadelphia Orchestra. Member of Stride since 1991. A youth local access television group that produced the show What's Up. Later I reproduced the show at TCC from 2001 to 2003 called What's Up? College Edition. I was the producer of the show and the president of the club. Starred in multiple PSAs for television. EFN, Food for Thought, 1990 Pecan Stuff, 1992. MTV Rock the Vote, About Us, 1994 Evergreen Law Group, Identification, Search, Shut Up. 2011-1992 Youth Hall of Fame Creative Genius Award for creating poetic / rap form of the classic Storia. Hamlet. The work was published in Ocean Edge magazine in 1993. My name was engraved on two stones in the Tacoma Mall for 10 years honoring the Youth Hall of Fame. Guest on Tacoma Radio Y.104.9 for the song Blood Oath, a tribute to Urban League Academy. Teacher, Michelle Beaupre. Published poet for the Tacoma Northwest Dispatch newspaper 1998 to 2002. Multiple works published in El Caucho magazine, a Latino newspaper in Tacoma, WA. 1999 spokesman for Evergreen State College Tacoma Law Club. Worked on expungement clinic. Participated in the San Francisco Clio LSAT workshop. Guest on the Podcast Institute for Black Justice, hosted by Carol Mitchell. Promoted the book, The Obia Woman, 2021 hip-hop historian and creator of the Serve I Notice Hip-Hop Museum on Facebook. Highlights: Northwest hip-hop and a broad history and cultural narrative. Features live interviews, information, and links. Also features the blog, The Artifacts newsletter, written and published by myself. Professional experience. Public speaking and leadership. I am a professional performer that have been in the spotlight since I was 12 years old. I have perfected my craft through years of educational training, practice, and life experience. For this reason, I am usually the face man when it comes to promoting a group effectively. I am a published author, and I have acquired multiple skills throughout my years of educational training. I am highly creative and can usually come up with groundbreaking ideas when brainstorming alone or in a group. Youth Hall of Fame Creative Genius Award. Empowerment Zone Spokesman for the Youth and Young Adults of Tacoma. Spokesman for the Law Club at Evergreen State College, Tacoma. Employment History Northwest Dispatch, Tacoma, Washington 1992 to 2001 Reporter/Poet Journalist Tower Records, Tacoma, Washington 1992 to 1994 Buyer, Cashier, Customer Service, Custodian Texaco Gas Station, Tacoma, Washington 1995 Cashier/Product Stocker/Customer Service Professional Services Unlimited, Fort Lewis, Washington 1996 Dishwasher/Busser Do Well Services and Supplies, City, State, 1997 Commissary Warehouse Worker/Custodian Strive, Tacoma, Washington 1991 to 2003 Reporter/Director/Camera Tech/Video Editor/Spokesman Evergreen Law Group, Olympia, Washington 2012 to 2012 Paralegal in Training DSHS, Anastasia Armour, Tacoma, Washington 2017 to 2021 Home Care Assistant Education Stadium High School, Tacoma, Washington 1992 HS Diploma, General Urban League Academy, Tacoma, Washington 1998 Certificate, Business Communication/Typing Tacoma Community College, Tacoma, Washington 2008 Associate of Arts, Business Administration Bates Technical College, Tacoma, Washington 2008 LL.B. Barber/Stylist Bartending Academy, Tacoma, Washington 2008 LL.B. Mixologist Evergreen State College, Tacoma, Tacoma, Washington 2012 Bachelor of Arts, Liberal Arts Communication Skills Reading, Writing, Leadership, Public Speaking, Typing, Acting, Performing Arts, H. Paralegal Experience Business Communication Negotiation, H. Video Operator Editor Creative Ingenuity Customer Service, Publications The Obia Woman by Anastasia Armour, The Obia Woman at Amazon.com August 2017 Novel Book The Artifacts Newsletter The Artifacts Newsletter Blogger.com April 2022 to the Survey Notice Hip Hop Museum The Survey Notice Hip Hop Museum Facebook.com March 2022 Northwest Dispatch Multiple Poems for Newspaper by George Hoyte Virginia Taylor, Pat Richardson January 2002 The Evergreen Law Club Tacoma Facts Newspaper Tacoma, WA January 2011 Affiliation Spokesman/Reporter/Director/Camera and Veto Tech Strive Tacoma, WA 1991 to 2003 A Spokesman for Youth and Young Adults of Tacoma, WA Tacoma Empowerment Zone Team Tacoma, WA 1993 to 1994 Camera Tech/Actor Law TV Tacoma, WA 1999 to 2003 Paralegal in Training Evergreen Law Group, Olympia, WA 2011 as Student Body Senator Tacoma Community College, Tacoma, WA 2008 to 2022 Licensed Mixologist Bartending Academy, Tacoma, WA 2008 Traffic Control Flagger, Tacoma Community College, Tacoma, WA 2008 Barber Stylist, Bates Technical College, Tacoma, WA 2007 to 2008 Training LSAT Prep, Clio Law Conference, San Francisco, CA, 2011 Honors Hamlet, Rap, George R. Hoyte, Youth Hall of Fame Creative Genius Award, Tacoma, WA 1992 ASG Scholarship Award, Bates Technical College, Tacoma, WA 2008 Talent What's Up /What's Up College Edition Producer/Performer/Director/Actor Strive Honor Roll Remember George Rampage Armour of Black Sheep of Tacoma Full Movie Producer Performer Actor Director Editor with the Students Television. Check out my new book, The Lost Sheep Blog, Evergreen Tacoma 2009 to 2012, by George Rampage Hoyte. Exclusively Amazon.com. $14.69 hard copy. 99 cents Kindle copy. Buy your copy today. Support for the Black Sheep. Description: enter the world of Tacoma, Washington, the 253, with Survey Notice, aka George Rampage Hoyte, Dominic Fortune, the infamous Game Untamed, as we take you through the 80s to the 2000s with celebrity interviews in the Northwest, to college interviews during the strike. What's up? And what's up? college edition spanning from TCC, Bates, and Evergreen State College Tacoma. Warning. Some footage is really old and underground grimy, so I apologize for the rough quality. However, it is a journey through memory lane for those on Hilltop who live it. Subscribe, comment, and find me at www.myspace.com/Servanotis Facebook.com/Servanotis Facebook.com/Evergreen Tacomala Boomdizzle.com/Servanotis or email me at servanotis@gmail.com. See you soon. Servi Notice.
Obia Woman by Anastasia Armorer. Author, George Hoyte. Editor, 4.7 out of 5 stars. 6. Prepare for a magical, spiritual adventure that takes place on the island of Trinidad. A land brimming with soul, culture and the mysterious practice Caladobia. In the book The Obia Woman, you will follow the story of Dora Van Hart, or as the people of Trinidad call her, Mother Dora, through a magical tale that follows the life of an Obia woman as she uses her mystical secrets to both aid and engage in spiritual warfare in the service of her people. The Obia law, passed in Jamaica in around 1898, remains in force with only a few minor amendments today. In this book, The Obia Woman, by author Anastasia Armorer, you will experience the fictional account of a secret practice of Obia as revealed through Mother Dora. Along with beautiful illustrations of full-color portraits of the hidden black gods and goddesses, and a tale that will transport you through life in Trinidad and spiritual warfare with hordes of the dark side, the only thing left to do is brace yourself for a fantastic cultural adventure in the book The Obia Woman. Biography Anastasia Armorer, who has traveled a long road since her girlhood in the mountains of Trinidad, writes about mystic adventures in her novels. Drawing on this African Caribbean tradition, which she learned from her aunties, she puts the healing and good magical powers of the Obia women African American culture in her books. Anastasia Armorer has been student body president at Tacoma Community College, in Washington, where she holds an associate degree. She has been a social worker and a community organizer. Her novel is growing as fantastically as one of the spells of the Obia woman herself.
Writ of habeas corpus concerning George Randolph Hoyte Jr. to the court concerning the involuntary empoisonment of the body and person of George R. Hoyte Jr. I am requesting the immediate release of Tay defendant and forced medical treatment from police and fire department and the unmust exploring and invasion of home and property. We direct to violations provided and protected by Bill of Rights in America. Home invasion. Kidnapping, no due process assault. Destruction of private property. Possible arson. Asset removal. This is the second time the police have attempted a home invasion of my apartment, and I want to be free from this harassment and be compensated for my pain and suffering. George R. Hoyte. Last Will and Testimony. By George Ramsage Hoyte Jr., George Randolph Hoyte Jr., George Rampehayamur, Dominance Fortune the Infamous Game Untamed, Servi Notice, R.A. Destruction, Salim Osiris Shabazz, Dismas Emmanuel Amur. To whom it may concern. By no stretch of the imagination am I suical or particulti homicaland. However, In the event of my untimely death for any reason, I of sound mind and body do leave all my worldly possessions, donated to the Evergreen State College Tacoma campus, Maxine Mims / Carol Mitchell, IBJ. In the event, there is to be no resuscitatin, not equals no organ donorship. Just burn the body. I love you all, Tacoma, WA. Yours truly, GRA, Black Sheep of Tacoma, Zmas Ea Tel Victoria. Dear Vina, Spanish Hills Management. I have read and reviewed your noticeably signed eviction document, and agree that the perceived facts seem concerning. However, the lack of due process in this case and the fact that this is the second home invasion in 6 months leads me to believe that the true facts of the matter can be resolved strictly by reviewing the unedited footage of the firefighters and police body cameras from forced entry to kidnapping without due process to involuntary imprisonment. Please consider these bodies of evidence before making any further reckless accusaciones. George R. Hoyte 2,533,015,421 room 1416. To Wellbound Doc Unit. I understand that due to a lack of my medication, I was admitted into involuntary care at Wellbound Hospital. After weeks of treatment, I am feeling fine, and want to be discharged as soon as possible. Things I need: my food stamp card, my Apple insurance card, social security card, and a bus pass. Spanish Hills Living Conditions should know a plan where meds can be delivered to my door. These are my requests, and I'm asking to be relieved from custody immediately. Thank you, Gr. Hoyte. To Tom Horton. I am hoping for a temporary discharge as soon as possible, as I need to pack up my belongings and put them in storage since I have now been evicted due to the lies and half-truths of the police and fire department. Judge and Mr. Josh Cook. I went out today to take of my business. My eviction is due on the 8th of July. I have a lot of packing to do. To Maxine Mims. In the event that I cannot hold on to my mother's works of art, I give them to Maxine Mims and Carol Mitchell, who have proven to me that they are most capable of using their mysterious powers responsibly. To my SW, I would like to set up my EBT card and Medicaid card as soon as possible. Thank you. To Mark Anthony Urban / Chavez. I am writing to request a copy of the transcript and any video / audio of my trial for my personal archive. I am also requesting an appeal on this decision, as it is my estimation that mens rea and foul play have been involved. I am also requesting the other 2 court appearances transcript / audio / video done in November-December 2022 at Multi-Care Hospital. To Dr. Hoa, Dr. Emily Robinson of Ellenmore. Dr. Hoa was the one who signed my beloved mother's death certificate. At the time, so much madness was going around me that I never got to say goodbye to my mother, Anastasia Armorer. I would like all documents, video and audio, and what was done to save her life, and her final moments, immediately. To Dr. Emily Robinson. Whether strictly liable or negligent, your steroid injection was the catalyst that made my mom's inflammation spread so fast around her body she was unable to move. This matter is far from legally settled between us. To Angela Naylor, CEO, Chris Rakinas, CFO, Brian Neal MD, CMO, Ryamian Service, CCO, Crystal Edwards, Director of Utilization Management. We the inmonts both voluntary and involuntarily, by way of expectation under constitutional law, and just plain human ethics, have certain demands that we want to see happen here at EWB Hospital. We want access to internet and email facility for the patients. We want a room provided for exercise equipment. We find it ridiculous to be constantly fed and not be able to work off calories contributing to poor health. We want the right to refuse any medication that would destroy or change sexual energy or orientation to be charged with a crime before a crime is committed is illegal at worst, and unethical at best. We want complete access to the local and global news. The excuse of trigger to keep us isolated from the outside world is unacceptable. Those that don't want to see the news always have the power to leave the room. Only the universe or the Most High gives or grants rights. Rights are a manner of ownership. We, as living entities, as the sole owners of our purpose and our journey. Therefore, we humble challenge whether our rights can be diminished or taken away under any circumstance. Rights can only be imposed by a corrupt government. that has tread over the Bill of Rights, and now threaten the belief of rule of law here in America. Sincerely yours. Chattel named George R. Hoyte Jr., Acutal named Dismas Emmanuel Amur. Dear Wellfound, I am making a few requests concerning my situation here at Wellfound, and would like to be pointed in the right directions to those who could help me. The true nature of my illness, I would like to speak to my provider and perhaps see their files concerning my treatment for said illness. I would like a copy of the fire department and police report, including unedited body camera footage of both for my personal discovery and defense testimony. I would like multi-care involuntary administration, no due process, of my person in November of 2022. Paperwork files and all audio/video conflict footage for my personal discovery for my archives. I also request all conflict footage audio/video from Wellfound along with all court transcripts from my archives for discovery and defense testimony. I will be requesting from Multicare all files and footage of the death of my mother, Anastasia Amur, as her HCA and only son. In short, I will be seeking to countersue for all rights diminished or
Dominic Emery serve a notice at gmail.com 6:47 a.m. 1 hour ago. To Spanish me, Spanish, Carol. Please be safe. Inbox search for all messages with label inbox. Remove label inbox from this conversation. Vina Coke Grenink mail system at Grenink. Mailer. Apolio. Us. 2A March 7th, 9:27 a.m. To me. Dear residents. This notice is to advise you of suspected criminal activity in the community. Management has received notice of, and the local authorities are currently investigating the incident thoroughly. Residents with information or questions regarding the incident are encouraged to contact the police department. As a community, it is in everyone's best interest to remain smart, alert, and proactive at all times. It is recommended that you become acquainted with your neighbors and stay alert to any suspicious activity. When walking within the community, it is suggested that you be accompanied by at least one other person with whom you are familiar, and remain aware of your surroundings at all times. It is recommended that you keep your apartment, home, and car doors locked at all times, and be sure all windows are securely closed and locked. Always look through the peephole before you unlock and open your door. It is recommended that you do not open your door for strangers. Please note that a courtesy patrol officer is available on the property. The courtesy patrol officer is not the police and cannot ensure your safety or security. However, the courtesy patrol officer will provide assistance if possible. The telephone number for the courtesy patrol is 253-535-4433. Telephone 253-535-4433. If a crime is suspected occurring or needs to be reported, please dial 911 to contact local law enforcement immediately. After first calling the police, please report all incidents to the management office or appropriate on-site personnel. This notice is intended to provide beneficial information allowing you to make appropriate decisions regarding your personal safety. Crime occurs everywhere and no one can ensure your safety or the safety of your belongings. Be advised that you should maintain insurance coverage for yourself, your vehicle, and your other personal belongings. Please remember that your security is your responsibility and that of the local law enforcement. Dominic Emery serve a notice at gmail.com. 2:45 a.m. 4 hours ago.
To Vina. Dear Spanish Hills Apt. Management. I deny all charges, if in fact there are any actual legitimate charges. I have lived here since 1999. I have no intention of leaving. I don't understand why I have been paying for apartment insurance for years and not being able to use it. I have been attacked without due process twice, and I am sick of the excuse of mental illness being used to justify my persecution. There are too many questions in this case for me to just pack up and leave without due process, and I don't believe Spanish Hills have clean hands on this issue. In short, I will see you in court. George Hoyte. P.S. If you need to reach me concerning this legal matter, please email me and set an appointment at servanotis@gmail.com. I will be in today to serve you this written document and to pick up my mail. Thank you.
Hello, my name is George Randolph Hoyte Jr. That's my government name. I got served papers that they want me evicted out of my apartment. I'm just going there. Today's the 14th of August. The day is due for me to give a response. I gave a response by email. I'm going to deliver the papers to the office today. My response, I basically deny all charges. I don't care who said it, the school, Lori Arnold, anybody I know, any hearsay, the police, the fire department, or anybody who just saw it, witness or whatever. Basically, I agree that this matter will be settled in court. There's too many questions to just pack up and leave off the world. So I'm going to fight this, and I'm taking this to the manager. I'm unarmed. I'm just going to go to the manager's department, keep this rolling, and give them the papers. So come with me. Paperwork in my bag, so I'm holding the camera. So I'm not really savvy with technology, but I don't believe I should be persecuted for that. Turn this on. To the pause as you can see, what's been done to the outside of my door. These people have been breaking in here. No matter what I do, I can't keep them out. Deliver these paperwork, and so I get this business together. Today's the last day to deliver it. I discovered it during the weekend by my door. It was the weekend, so today's Monday, the last day. Here I go. So. Ringing the bell.
Hello, how can I help you?
It's George here to serve this response to the paperwork, and I'm here to pick up my mail.
Thank you. Hi, Carlos. Good. Hi, George. Your package is here.
Here, and here's your response to your letters.
Okay, you have to send this to the attorneys.
Well, I just want to be right now that I just got it over the weekend. This is the last day. Will you please accept this one? This says I deny all charges. I deny all accusations, and I recognize this is a matter for the court to decide. Well,
fax over to the
I can't fax it right yet, but I did serve you these papers in my response. I agree. I deny all charges if there's any real charges. I deny all accusations. I don't care if it's from a teacher, somebody who knows me, a dog who knows me, a high school. I deny all charges. Thank you. Thank you.
It's impossible! I never broke the law! I am the law!
Welcome to the seminar involving record expungement and post-discharge relief. My name is Nigel Malden. I'm an attorney here in Tacoma. I do both civil and criminal law. And I'm here today with Blake Kramer, who's also an attorney in Tacoma, who does both civil and criminal law. We thank you for taking the time to come to the seminar today. We're hoping to provide some useful information and insight regarding an area that we think is interesting and perhaps getting more and more important every day. We're going to be focusing on there's different terms that can be used. I use the general catchphrase clearing criminal information or clearing criminal conviction data, just because it's sometimes a little more clear and less likely to confuse. There's three different types of procedures that we'll be talking about today. One of them is called expungement or expunging, another is called vacating, and the third is called sealing of court records. There's a tendency that people have, lawyers and others, to mix and match the terms or try and use them interchangeably. And one of the goals that we have today is to try and explain and make sure all of you understand that there is a difference between these three types of terms. And people commonly come in and they ask a question about expungement. That seems to be the word that so many people are familiar with. And yet it doesn't really apply to to what may be the common situation where someone has a criminal conviction that's now several years old, and they want to be able to seal the record. Well, they want to be able to vacate the conviction and seal the record, and then be able to report to anyone that asks that they've never been convicted before. Expungement generally refers solely to the removal or the excising of non-conviction data from law enforcement and investigative agency records. As we get into the presentation today, hopefully we'll explain more clearly the differences between those things. I was very interested and excited to do this presentation because I myself think this is a really interesting area of law. I think of it in terms of the privacy and prejudice, the invasion of privacy and the prejudice that can occur in an internet age where so much information is available on so many different people, and there's so many people selling that information on the internet. It might be more important than ever to try and protect one's privacy and do whatever they can to make sure any criminal records or any investigative records can be sealed from view where appropriate. One of the reasons that I saw the importance of this and had it put in context for me was I got a call a while ago from a lady. She was very, very concerned. Her son had been admitted to medical school, and he had had a stellar college career, and he was all set to move and start medical school, which was the realization of a dream for him and his family. But his admission had been conditional. Apparently that's a term that's used often in educational settings where the schools will admit someone, but they basically have a small little disclaimer or condition that basically says, but we will do some further background checking, some investigation, confirmation of the accuracy of your materials, and technically we could still deny you admission on the day of classes. Well, the person that called me was very concerned because her son had gotten a call from the dean of admissions at this medical school, and had basically ordered him to fly down there special to undergo an interview and explain his criminal record the day before, a few days before classes were going to start. And they were all very, very concerned for obvious reasons. The thing about it is, though, I got into the conversation, I realized what we were talking about, and naturally I eventually asked her, well, what exactly is the criminal conviction that they're talking about? And as a lawyer, having practiced for 25 years or so, I've heard a lot of stories. I've heard some terrible things. I empathize with my clients and tend to feel bad and do what I can to help them. I was expecting the worst. But what this lady told me was her son was being hailed down to meet with the dean of students because he had a conviction for fishing without a license on public property. And I was just blown away. And I told her, you know, I'd be very glad to do the paperwork, and I can explain to you expungement and vacating and sealing, and we can do all of this for you. And obviously they were in a position to pay for whatever was necessary for me to do a Cadillac job on it. But I actually told her, you know, I can't believe this is true. There's got to be a mistake. Before you get all worried and concerned, have your son go into that meeting, because I can't believe that a school would deny someone admission for fishing without a license. And fortunately, they followed my advice, and that's exactly what happened. The young man walked into the room, freaked out, but the dean of admissions started laughing and basically said, I'm sorry, we made a mistake. We wouldn't have hailed you in here for this kind of a thing, so go on your way. We're happy to have you. So that story had a very happy ending. But it made me think a little bit, do a little research about how lives can be affected by all of this data that's being generated. about things, and how it can affect one's employment, how it can affect professional licensing. You know, the state now licenses a growing array of vocations and professions, all of which involve a procedure of checking backgrounds and qualifications and making decisions whether people should be permitted to practice their area of interest or not. It also affects things like immigration status. I'm not an immigration lawyer, but I understand that in this day and age, people can be deported for what we might think are relatively minor criminal offenses. There's also potential ramifications to things ranging from availability of housing to, of course, one's right to own and possess a handgun. So there's a whole bunch of reasons why people may be interested in investigating and clearing any criminal record that they have. Before I turn things over to Blake, I'd like to digress for a moment and get back to my original point, which is we're talking about three different statutory animals: expungement, vacating a conviction, and sealing a court record. All of these things, well, expungement and vacating are creatures of statute, which means the right to obtain the remedy. It's laid out strictly by statute. The conditions and so forth must be strictly met. Expungement statute is RCW 10.97.060. Expungement generally refers to non-conviction data. If someone is arrested, their fingerprints, photographs, and other information may end up in a file at the Washington State Patrol. If that person is not ultimately convicted of a crime, the information and material regarding that individual may still sit there in the Washington State Patrol file for years, unless an effort is made to have it removed or expunged. Vacating a conviction is something very different, and the two statutes there we're concerned with are RCW 9.96.060 and RCW 9.94A.640. Before I go any further, I do want to apologize because I was responsible for a portion of our outline, and I correctly cited the one statute. I'm looking at our outline, Roman numeral 1, clearing a criminal record definitions, subheading B, vacating convictions under RCW 9.96.060. I neglected to add to that and RCW 9.94A.060. I think Blake will explain here in a few minutes the key distinction where one statute governs misdemeanor criminal convictions, the other governs felony convictions.
Which, can you give those RCWs again?
The first one, it says in Roman numeral 1, section B, it says vacating convictions, and then it's already typed in 9.96.060. And then we'd like you to add next to that, just to make this accurate, and 9.94A.060.
640.
I'm sorry, 640. You're correct. Thank you, Don.
Blake is going to explain more about this, but just to give you the general overview, vacating is generally a situation where someone has been convicted of a crime by a court, and at some point, in the right conditions, when enough time has gone by, when there's been no other trouble, if the conviction is not of a certain variety, then after a period of time, if conditions are met, the record of conviction may be vacated. Sealing of the records is something that it's not a creature of statute, it's a creature of superior court rule, and that's General Rule 15, or GR 15. GR 15 is the rule that instructs the courts how to handle a request that someone may make to seal their record. There's a big difference between the destruction of a record and the sealing of a record. If a record is destroyed, it doesn't exist. No one can see what's not there. If a record is sealed, it still exists, but access to it is limited or restricted. So GR-15 is a mechanism that allows people in certain circumstances to have their court records not destroyed, but sealed from view. We're going to be getting into all of that in some detail. I just wanted to give the general overview so that you would be oriented when we got into it. Blake, would you like to add anything about...
First of all, as usual, great, clear comments, Nigel. I appreciate you laying it out like that. I agree with what he says. Thank you, by the way, for being here. Most of you are affiliated with a volunteer clinic and are here for the same reason that motivates Nigel and I. It's really nice to be able to help people out when they're, particularly when they're desperate for help and can't afford the work that we typically do. So I applaud you all here who are working to help people out of bad situations. When I think of a bad situation, I think of somebody coming into the volunteer clinic, and there may be somebody who are in their early 30s, and then when they were about 20, maybe they had a brush with the law and got a conviction for possession of some drug or something. Now they're in their early 30s. They have had a job for 5 years that they've been doing really well at, but the business isn't doing well, so they had to lay some people off. They laid that person off. That person now is going around in the job market looking for work. And people quickly find that this person has this conviction from so many years ago, and they have 100 different resumes on their desk, and that's the first one that they take and throw in the garbage can simply because it's an easy thing to do. So now this person is having a hard time finding a job, and they can no longer afford where they used to live, so they're trying to find a smaller apartment to live in. And every time that they apply for an apartment, the person screening them finds out that they've got this conviction from when they were 20, and again, they get tossed in the garbage can. So here's a person who no longer has a job, can't find a job, is having a hard time getting work, having a hard time finding a place to live, and they can't go to a lawyer and pay $2,500 or whatever to get some help, so they come into us in the volunteer clinic and say, what can we do? And typically what they'll do is they'll walk in and they'll say, I need an expungement. And they say that because that's the word that's passed around a lot, and it sounds like what they want. So the first thing that we need to do when we're working with these people is we need to start off by saying, okay, what is it that you need? Why is it that you think that you need an expungement? And so we need to start using our interview skills to find out what the concern is that they want to address. And then we're going to figure out, as Nigel has laid out for you, whether what they need is an expungement because they never had a conviction, whether they need to vacate a conviction because they were convicted but a certain amount of time has passed, and whether or not they want to seal a record. So that's what the CLE is about. In this economy where people are really on the ropes for work and for applying for housing and everything else, this is exactly the sort of thing that lawyers like us need to work really hard to do to help people in the community out.
Before we turn to Blake and have him lay out for us the procedures for vacating adult convictions, I'd like to say one other, I guess it's more of an introductory comment. Before we started the lecture, there were several of you that were asking questions about, well, will we address how to eliminate data that may be somewhere on the internet? Maybe it's not even an official governmental or law enforcement site. And I actually think that that's a very interesting question, and I think it probably is helpful for me to make a point. It may seem fairly elemental, but I think it's important. I have people all the time ask me in a variety of contexts, is this on my record? Will this be on my record? It's a very common question that people ask. And invariably, I have to ask them, well, what do you mean by a record? Because I can go on to the Washington State Court's record site, and I can tell you whether there's any record of a criminal or civil case in your name in the state superior court system. And I can walk up to the Pierce County District Court. I can also do some electronic access to the district court site. I can also walk up to the Tacoma Municipal Court records and search those. But there is no way that I can tell you what may or may not be on record in some city or county or state where you ran into trouble perhaps years ago. There's no one uniform repository of data that a lawyer can go to modify or change or seal and remove people's concerns. The scope of this presentation really is, well, what can we do in the state of Washington to deal with a record of conviction or a record of arrest? I mention this because, again, I think some people have the notion that there's this official government database. Maybe it's maintained, by the FBI or the CIA or something, and all records from any city court or county court or state court or federal court all go into that. And it's one-stop shopping where you can somehow fix it all in one fell swoop. And I just wanted to make sure that we explain that's not what we're talking about here today. The question about how does someone go about eliminating false, erroneous information that may be maintained about them on some website by a third party, that's a fascinating question and another cutting-edge area of law, but that really is a bit outside the scope of what we're trying to do. With that caveat, Blake, would you like to take us through the procedures for vacating adult criminal convictions in the state of Washington?
Thank you. Sure. So now we're talking about a situation where this person has come into the clinic and you've begun to question them, to ask them what they mean by expungement. And they say, well, I was charged with possession of controlled substance back in when I was 20, about 12 years ago. And it's on my record, and my landlord slash my boss, somebody is or may soon be coming up with that information, and I want to get that off my record. So what they're talking about is, in that case, is a Class C felony. And felonies are, felony vacates are governed by RCW 9.94A.640. Now, there are limited circumstances under which a person is eligible to have a vacate done under that statute. The first is that this statutory procedure governs convictions that occur on or after July 1st of 1984. Second, it's only good for somebody who has no charges pending. And somebody might come into the clinic, they might have a current charge in Pierce County Superior Court, and their lawyer might have told them, well, you're in lots of trouble because you've got this old charge. They're not eligible because they have a current charge pending. As a matter of fact, you also need to understand that this is like a deferred prosecution in a DUI case. Each person is only allowed one in their lifetime. They're allowed one vacate. And if they have multiple convictions, they're only going to be able to vacate the most recent in time. The statute says that they have to have no subsequent conviction since they were discharged from their sentencing requirements. And this is an important term that I want to stress to you. It's called a certificate of discharge. And what this means was that after somebody was convicted, they were given a sentence, and at the completion of their sentence, a certificate of discharge is supposed to issue. It doesn't issue until all conditions are satisfied, including legal financial obligations such as restitution. So if a person isn't making their restitution payments, then the certificate of discharge may not issue. Well, now that's a very interesting question I'm going to get into. It's supposed to be automatic, but I'm going to get into that later on, and please bring it up if I don't. Additionally, another condition is that if this person is only eligible for a vacate if it's been 10 years since they've received their certificate of discharge, if their conviction was for a Class B felony. Or if it was a Class C felony, there has to be a 5-year period. If it's a Class A felony, then they're not eligible. As a matter of fact, I put a list at the very back of your materials, and this is put out by the Innocence Project. And this is a list of all of the convictions that are not eligible for vacates. And generally they break down into Class A felonies, attempts on Class A felonies, serious violent crimes, crimes against people. These are the sort of crimes for which you have to say to them, oh, I'm sorry, a vacate is something that you're not eligible for. So once you go through the interviewing this person and you realize that they're eligible for their record vacated, then you need to start them on the basic steps. The first step is that they need to obtain their personal criminal history. They have to get a criminal history that they're going to be able to use to verify the fact that they've got no subsequent convictions, to verify that this conviction is what they're working on. And the easiest way to do that is to go on the website for the Washington State Patrol and check for the personal criminal history log. Now it costs $10. You send in a check for $10 to the Washington State Patrol after printing out their request for this criminal history. In return for this, they will send you an unofficial criminal history record. Now, in my experience, this is what I've used. I go into court in different counties, and prosecutors and judges accept this. However, after completing their package and submitting it, they may receive a complaint from the prosecutor or the judge that that this is not adequate, in which case they should obtain a certified criminal history. And the way you do that is a different procedure. You go down to any police station and you request something called a fingerprint card. And they'll go do an official fingerprint card, and you should tell them that they should get 2. Then they should take those fingerprint cards and they should send a check for $25 to the Washington State Patrol at the same address that they would have sent the $10 to for the informal history. And they should write a cover letter, and they should say to the Washington State Patrol that they are specifically requesting a certified criminal history, and that they want, and that they're doing this because they are currently preparing a motion to vacate a conviction on their criminal history. Then,
if you could explain one thing, Blake, does the informal or uncertified record that one gets directly from the State Patrol, is that sometimes deemed acceptable? You can use that?
yeah, absolutely. And I have used it again and again. I have never needed to go through the step of getting a certified record. But it's important that we know the procedure in case somebody comes in and says, I received trouble on this. Usually the $10 informal one that you get from the Washington State Patrol is good enough.
So it could be a particular court somewhere in Washington might have some customer practice where the State Patrol record is deemed insufficient. Is that what you mean?
No, actually, my concern is that some prosecutor is going to go, I'm suspicious that this person is not who they say they are in this particular case, or I'm suspicious that we're getting confused on 2 different criminal histories here. I want this person fingerprinted. So I think that it could happen in any court. It just hasn't happened to me yet. And ma'am, you have a question?
Well, I do some of these occasionally, and one time it happened that the prosecutor required an FBI report. I don't remember what he called it, an IP or I something. But yeah, we had to come back and actually had to bring that in.
Okay. I've never had or heard of anybody having to get an FBI record, but it's possible. This second procedure should do it, because when you get the fingerprints done, then they can, when the Washington State Patrol runs the criminal history, then they can do a complete check, and they can run it through the FBI database. So that could be what they were talking about, because through the Washington State Patrol you get the benefit of that once you do the fingerprint cards. So if you have to go through this secondary procedure, it tends to take up to 8 weeks. You can call up the Washington State Patrol at a phone number on their website to check out the progress of that if it's not coming through. The next,
do the police agencies charge you a fee to take the fingerprints? Do you know?
I have not heard of them charging a fee for the fingerprint cards. So now the next step, once they get that going, is to go and get a copy of their judgment and sentence in their original case. And that's simple enough. Here in Pierce County, you go down to the clerk's office, you give them your case number, and you say, I want copies of this, and they're going to charge, I think, $1 a page to print those things up. At the same time, you also want to request the certificate of discharge. And If the certificate of discharge is not in the file, then you got a real problem. What they can do is there's actually a statutory procedure to petition for a certificate of discharge. And you know what? I'm going to get into the end of this at what to do if it's not in there. I'm just going to keep marching through here. Next, what they need to start doing, and you can start working with them, is they need to fill out a motion to vacate. And I have included a form from that from the Innocence Project. And unfortunately, we don't have page numbers, and this is where it gets fun for you here. So this is the defendant's motion to vacate, and it's pretty self-explanatory. You just start moving through the form and filling in the blanks as they're required. Next, at the same time, you're going to have them fill out a declaration in support of their motion for order to vacate, and that's the next form that's included in the package. And again, self-explanatory. You fill in their convictions, and they're attesting to the fact that this is their only conviction, or that this is their most recent, and that they complied with the terms of RCW 9948.
Yes. One question I'd like to ask you, Blake. This was actually posed by someone before we officially started today. I thought it was a great question. I think the person was trying to get some guidance on, do you think that the average person, non-lawyer, if they made a little bit of effort, would be able to navigate through and get these documents properly filled out? If someone is working at the clinic and someone comes in and looks like they have a basis for filing a motion to vacate, what kind of caution do you think would be good to give people? Does this take a lawyer? How much effort, special research would it take someone that doesn't have any legal training?
Well, that's a great question. The answer is that yes, the motion to vacate is relatively simple, and sometimes prosecutors and judges will just agree without any argument that in this case it's appropriate. The place that we're really helping these people is A, putting the forms in front of them and showing them what needs to be done. B, we're really answering the basic questions, helping them to answer the basic questions of whether or not they're eligible, whether the correct amount of time has passed, whether the conviction is one that allows them to get a vacate. And the statute says, well, it's serious violent crimes, it's crimes against people, but we want to interview these people and find out exactly what they were convicted of and help them to answer those questions. And then there's some techniques that we're coming up to that we can kind of help them with that will perfect their ability. So yes, they might be able to do it on their own, but we're certainly going to be able to do a lot of help for them. Then the next thing that they need to do once they've completed their motion and declaration in support of motion is that we need to tell them that they need to make 3 copies of these originals, that they need to attach their judgment and sentence and certificate of discharge to their declaration. They need to make 3 copies of all these things, and then they need to march themselves down to the clerk's office. Now, when they get to the clerk's office, they're going to be submitting this not as a new case, but as a motion on their original case. So that means that when we get to when they're doing the motion and everything, you'll see up here where it says case number. They're just going to put the same case number under which they were originally charged and convicted. Now, the cool thing about this is that since they're not filing a new case in Pierce County Superior Court, then they're not paying a new filing fee. This saves $220, which is a lot of money to the sort of people that we're helping out who are in dire straits and coming to the voluntary legal clinic. So they need to go into the clerk's office, and the first thing that they need to do when they get there is they need to fill out a note for motion. Now, we've attached one at the back of the materials. Most counties have their own. Pierce County has one that I believe is available in the clerk's office. Unfortunately, you can no longer print it offline like you used to be able to, because now if you go online as an attorney, it gives you the opportunity to do a note for motion electronically. But the pro ses that are coming in are not going to have access to this resource. So they're either going to have to use the one that I've attached to the back of the materials, which conforms with Pierce County's requirements, or better, they'll go and use one of Pierce County's own no promotions, and we can just tell them, because we all do motions, what no promotion looks like. You just fill in, this is a motion to vacate, and this is what I want to have it done. In Pierce County, motions to vacate are done on Tuesday and Friday afternoons at 1:30. They should choose a motion date that is 3 to 4 weeks away from the time that they file, and they should choose one of those Tuesday or Fridays at 1:30. Then what they should do is they should file the original with the court, or with the clerk's office right there where they filled out the no promotion. And then they should mark the first copy in the upper right corner. They should say bench copy, and they should drop that in the filing box as well. At this point, they have 2 more copies of their motion and declaration. We're going to tell them to stamp those at the clerk's office to show that they've been received, that the original's been received by the clerk's office. And then they should, in Pierce County anyway, they should march themselves up to the 9th floor prosecutor's office. They walk up to the window at the prosecutor's office, and then they're going to hand one of the 2 copies to the person accepting filings. And then they're going to hand the second one and ask that one to be date stamped. And we're going to tell them, make sure and get that date stamped. So then they should have 1 copy for themselves. And that copy is going to have stamp from the clerk's office and from the prosecutor's office showing that it's been received there. Then they should go home and they should sit down, and the next form in the material, or somewhere in the materials here, is a declaration of service. Here it is, it's right after the order. And they should fill out and complete the declaration of service, and we should tell them that they should make sure once they've filled it out, saying when they served it in the clerk's office and the prosecutor's office, we should have them also make 3 or 4 copies of that, so that when they eventually do go to court, they have that. Now, here's one little wrinkle in this, and that is that if there is a victim of the crime for which they were originally served, then that person should receive notice of this. Now, if they are still subject to a no contact order for the person who was the victim, then that is problematic. Now, the statute that governs this says that people aren't eligible to have crimes against persons. However, if there's a theft, they may fall under this. So you should ask them if there's a victim of crime. If there is, then they should mail a copy to that person or serve them, and then they can say on the declaration what they did to provide notice to that victim. And I'm sorry, now, ma'am, you had a question?
Yeah, I was just going to ask you. You said the days that they do for the hearings, Tuesdays and Fridays.
Tuesday and Fridays. Okay. That's Pierce County. Okay. I've done it in Thurston County recently, and I think it was more wide open. They're going to need to find out from the clerk's office when they're at the window of whatever clerk's office what days are available for that. Okay. And clerks, as we know, are always extremely helpful on stuff like this. All right, now they've completed their declaration of service, and they've sent their document around. They should also make sure that maybe there's a cover letter that they put on the one that they send to the prosecutor's office saying, this is my name, I'm filing this, and this is how to contact me. As attorneys, we know that our pleadings have our names and address at the bottom. We need to make sure that these pro ses who are trying to do this on their own are somehow giving the prosecutor a way to contact them. What they should do at this point then is they should contact at some point, say a week from that point, a week or 2, they should contact the prosecutor's office and say, and find out who is handling their case. Now here in Pierce County, you can access publicly the link system and pull up any case and see who the prosecutor is that's assigned to it. Or else they can just call the prosecutor's phone number and say, this is my case number, can you tell me who the prosecutor is who's assigned to it? Then they should contact that prosecutor and they should say, hi, I filed my motion and declaration for vacate, it's this case number. Can you tell me, are you going to agree to this? Because sometimes the prosecutor is going to say, yes, I reviewed it, and we're going to go ahead and agree with it. And that's obviously going to make things a lot simpler for them on the vacate. The next thing is whether or not the prosecutor agrees to it. They're going to want to prepare for the hearing so that they can go and present this. And the first thing that they're going to do is they're going to fill out the order that's in this materials. The next thing that they're going to do is at this point you're going to sit down with them and you're going to talk to them about how to prepare for court, the sort of things that they should do so that they can effectively present this. And you're going to tell them, show up 30 minutes early, dress nicely, don't bring children if you can find a way to not bring children, and find the clerk of the court and introduce yourself as soon as you get there and let them know that you're present for your motion. If you can, tell them to try to find out who the prosecutor is and walk up to the prosecutor and say, hey, I'm here for my motion. Is there anything that we need to talk about or any last minute details that you want to go over with me or anything you're going to disagree about that you can tell me about in advance? And then you're going to go through a basic script of the sort of things that they're going to need to say to the judge once their case is called. And I suggest that the script you give them is something like walking up and telling them, introducing themselves, thanking the court for an opportunity to be heard on this vacate, then tell them that they've satisfied all the different preconditions of 9.948.640, no new charges, when they were discharged, that this was not a violent crime or a crime against a person, that they've served notice on everybody. And then one thing that I do when I'm representing people like this is I try to spend a little bit of time talking about the sort of person that this person is and the good things that they've been doing. And this is really important. One neat thing about these motions to vacate is that if you're in court watching these judges work, they get person after person in front of them who's either just been charged with something terrible or else they've got a case going on and they're maybe not doing good things while they're in trouble with this case. When you walk into court with somebody who was convicted of something a long time ago and they've been leading a very good and productive life, judges are very happy about this. This is just like a fresh of breath air. It makes them feel great that they've got somebody like, hey, look at this person. This is the sort of thing that I wish that the rest of you were like. So it kind of makes sense to kind of ring the bell, bang the drum a little bit, and talk about this. And you don't want this person to annoy the judge by bragging about the sort of things you're doing, but give them a chance to present the human element of who they are and tell them that might be good to say one sentence, maybe two, possibly three, but probably not more than that about the sort of person they are and the things that they've been doing. So then once the person has made their presentation, they're gonna stop talking and you're gonna tell them, don't interrupt the judge if the judge starts talking, don't interrupt the prosecutor if the prosecutor says why you don't deserve this. Just take your time, take deep breaths, wait for your turn for any questions to be asked. Then, if the judge should sign this order to vacate, you're going to tell them that what they're going to do is they're going to wait and ask the clerk of the court to take that original to the clerk's office themselves. They're going to march it down to the clerk's office, and when they get down to the clerk's office, they're going to ask for 5 certified copies. The certified copies of this motion to vacate are their little drips of golden sunlight that they're going to use to send to people to convince them to not do things. They're going to file the original. They're going to take their 5 certified copies home, and then they're going to send them to. They're going to immediately send one to the Washington State Patrol and anybody who's reporting their criminal history. Now, this is going to have effect on the Washington State Patrol. We can't guarantee that it's going to have effect, as Nigel was talking about, on some 14-year-old who's maintaining a website in Poughkeepsie or some businessman in Indonesia who runs a website. They can still use these things and hope that the people who receive them take this seriously. We know that the Washington State Patrol will. We're not sure if other people will. I'm sorry, Nigel, go ahead.
I may be jumping ahead, but I wanted to ask you this question. You've been talking about vacating conviction of a crime. What's the situation where, and I know it happens all the time, where someone goes to court and they're given, I believe it's called a continuance without findings, where they're not actually convicted. They're told that if you go through a certain period of time with no further trouble, if you meet this condition and that condition, then at the end of it, the case will be dismissed. I think we're going to be talking about sealing records here a little bit later, but just to keep this in context, is that a different animal than the procedure for vacating a conviction that you've been discussing?
That is a different procedure. In that case, where somebody has a continue without findings, then at the conclusion of their continue without findings, the the conviction, there's a dismissal that's entered on the record. So they don't have a conviction to vacate. In that case, the remedy that they're going to be talking about is something that you're going to get in at the very end, which is expungements. And it's a possible remedy.
Okay.
However, with vacating adult convictions, one practice point that you brought up that I wanted to get to is the last one I did was about a month and a half ago. I went down to court. There was no response from the prosecutor in that county. I walked into court that day, and they announced to the judge, as we got in front of the judge, that my client was ineligible for a vacate because it had only been 4 years since her Class C conviction had been discharged. And the reason that it had only been 4 years was that she had actually completed the terms of her sentence 7 years before, but the clerk's office had failed to file the discharge for 3 years for reasons that were unknown. There is a statutory procedure that allows you to petition the court to issue a certificate of discharge. And the implication that some might get from this is that the criminal defendant has a duty to go to court and ask for a certificate of discharge, but that is not the case. There is a 2008 case, State v. Johnson, that says that this is the duty of the court to issue the certificate of discharge once the sentence and legal financial obligations have been completed. And that if the certificate of discharge was not entered correctly, then the court, on motion to vacate, should look back into the record and determine when it should have been discharged. And the court should then fix a date accordingly. Now, the reason I bring this up, this is one of many different problems you can run into, is that I've heard of people running into this a fair amount, and I certainly ran into it. And what you need to do is you need to say, hey, this is the duty. This is not the duty of my clients, and there's case law that says that the court has the duty to issue this discharge. We can go down and try to, as I did and as other attorneys have done, try to enter what's called an order nunc pro tunc, which says that this order was entered and it should be rewritten to effectively reflect the date that the discharge should have happened. You don't even need to say nunc pro tunc. You just need to say, per State v. Johnson, all conditions of this sentence were completed on this date, and the discharge should have been entered on this date. And then the court should follow along with that and say, okay, I'm going to agree that that's done. So that is the procedures for vacating the adult convictions. And you know what? Nigel and I were really worried that we were going to be going too quickly. Instead, we're kind of eating up time like crazy. And I think we should get on to the next thing, which is vacating juvenile convictions, and Nigel's going to help. But does anybody have any questions on vacating adult convictions? Okay. And Nigel.
All right. Let me just ask you another follow-up question. I want to make sure that I'm clear on this, we're all clear on this. If someone's been convicted of a felony that is on that list in the materials, does that mean no how, no way can they vacate? It's just off the table forever?
I'm sorry, if they've been convicted of a felony that is on that list?
Right.
Yes. Then they are, unfortunately, they run into a dead end, and they cannot get it vacated. They certainly can't get it expunged. And they are undoubtedly not going to be able to get it sealed either.
So there's no point.
At that point, we should identify these people, and we should tell them, I'm sorry, the current statutory procedure does not provide a remedy for you in the situation. However, we can say to these people when it happens that this happens and this changes all the time. For instance, Nigel, you're going to be talking about how in juvenile procedures just this last year, it used to be that you could vacate Class B and Class C felonies. Just this year, they changed it to say that now you can, under certain circumstances, vacate an A. So we can tell these people when they come into the clinic and say, I have this very serious, violent conviction, can I get it vacated? We're going to say, no, I'm sorry, you can't, but this may not always be true. Keep checking back, keep watching the statutes. These things change. Similarly, it's a really good idea for somebody who's eligible for a vacate to get that vacate done now, because the statute may change next year in the other way, and what is now eligible for a vacation may not be eligible a year or two from now.
If someone had a conviction that they didn't timely vacate, and then unfortunately there was a second conviction, does the fact that there's been one conviction never vacated, does that affect their entitlement?
To the second one?
Right.
No, they're still at some point will be eligible, can look into the possibility of having their most recent felony vacated. They'll have to follow whatever conditions are appropriate for that. If it's a Class B felony, they'll have to wait 10 years before, after they've completed their sentence, before they can ask that that be vacated. But yeah, they will forever lose their right to vacate that first one, because you're only not allowed to vacate one conviction, and it has to be the most recent in time. Please, Bree.
Are the typical things that are done for this, like theft and things like this? I don't see theft on here.
Yeah, theft is not on there because it's eligible. Truthfully, the ones that I have run into have been drug related. That's the vast majority of the ones. These are people, I mean, a theft one is going to keep somebody from getting a job too, but for some reason, the vast majority of the ones that people have come to me with have been drug-related charges.
Sometimes you have two related convictions. It's still two convictions, right?
Well, I guess explain to me what you mean by related.
Oh, it's the same crime, but two different.
Two different times.
Well, two different. I don't know. But let's say it was drugs and theft.
Yeah.
It's the same incident.
From the same single incident. Okay, if it's from the same single incident under the same cause number, then they should be able to get that whole conviction vacated. I think.
There's multiple charges, but they're all sentenced on the same day.
You know what? I thought I knew the answer to that, and I realized I wish that I had checked. I have not run into that specific thing. Usually you're vacating a conviction. If there's multiple convictions, I'm not sure whether or not you're going to be able to get multiple convictions at one time. Actually, my feeling now is, from the way that the statute reads, is that you're eligible to vacate a conviction. And it has to be the most recent in time. So a person with multiple convictions for all kinds of different things on one day might be problematic. Yes?
If you have a felony and you have a misdemeanor, and the misdemeanor occurs after the felony, can you vacate both of those, or are you only going to be able to get rid of that misdemeanor?
You're only going to be able to get rid of the misdemeanor, because one of the conditions under 9.948.640 is that there's no subsequent charges, no subsequent criminal activity. And so a misdemeanor conviction following that serious felony conviction would then ace out the felony, and then you could use these procedures, essentially, the forms that we've included, to follow through on a misdemeanor conviction.
Another reason to get it vacated.
Yeah, well, you know, bottom line is, best thing to do is not get in any more trouble. But yeah, as soon as bottom line is, when you're eligible for a vacate, you absolutely should. Please.
How many felonies can be vacated at one time?
Just one. Each person can have one vacate in their entire life. Kind of like the way that our legislature has said that everybody's eligible for one deferred prosecution on a DUI charge, ever.
And I don't see DUI on this list.
Well, DUI is a misdemeanor, but under the misdemeanor scheme, which we've included in the first page, I think, or maybe it's the second couple of pages of your materials, there's certain things that you're not eligible to vacate, and I believe DUI is one of them.
You know, people leaving Department of Corrections are coming back to school, and a lot of people in worker retraining. And as you said, they have a job, and then when they lose a job, and now they're dealing with their records. What is robbery?
Robbery would be a crime against a person.
And that's not eligible.
And that's not eligible.
Wow. What could a person with a crime like that do to be able to just hope and pray for luck, or, you know?
Yeah, unfortunately, under the stuff that we're talking about today, absolutely nothing. There's things that they can try. And these are things that we'd rather not spend time on today. But we can talk. You can seek a pardon. You can seek clemency. But the truth is that once you get a pardon or clemency, you still, if you're asked the question, are you now, or have you ever been a convicted felon? The answer is still yes. So those people are in big trouble, and the current statutory scheme does not provide for them. Again, they should keep checking. It might not happen anytime soon. It might happen 10 years from now. It might happen never. But they should keep checking. Well, thank you, everybody. We're going to go ahead and get started again. So what we've been doing so far is we've been talking about the statutory scheme for vacate. We're a little bit worried about time. We've got materials in here about vacating misdemeanors. But rather than addressing that right now, I think we want to move on to the different issues that we have, and if we have time, we'll address whatever's left at the end. So, Nigel, can you please talk to us about juvenile convictions and what can be done?
Thank you. Before I get there, just one interesting footnote. Someone had asked, or I think I'd asked, and Blake had said, if they don't qualify for vacating the court conviction, if it's one of those felonies that's determined to be not eligible, that they're done, it's over, that's the end of the game. And Blake mentioned in passing that we don't really want to get into it today, but some of the minor, small little exceptions that possibly sometimes apply include a pardon. And very, very few of us ever have occasion to deal with a pardon. A pardon comes in the case of a state court conviction. A pardon would come from the governor of the state of Washington, meaning that the governor would review the terms of the specific case, and he or she has the authority under the Constitution and the law to make a decision. In very, very special cases and circumstances, they can pardon someone who's been convicted of a crime. And ironically, Blake is one of the few people I know that has been involved in a case where he successfully obtained a pardon. He happened to mention that to me in passing, but I was very impressed with it because I'm not sure I know anybody else that has ever obtained a pardon for anybody.
Thank you.
Anyhow, to move along, our hope was to touch on some of the unique things that apply when a juvenile conviction, when someone is trying to vacate a conviction that occurred when someone was a juvenile or under age 18. And a couple of general comments that I wanted to make. First, again, I've got to point out one shortcoming with the outline, and that I really should have, for ease of reference, I should have put the statute next to, this is Roman numeral 3 in our outline, procedures for vacating juvenile convictions. I really should have cited the statute, which is RCW 13.50.050.
One more time, please.
13.50.050. And maybe just for clarity's sake, I should explain when I use this word statute, I'm talking about it's the state law that's been enacted by the state legislature. And for people that may not be lawyers, we use the shorthand RCW. That stands for Revised Code of Washington. So, like the issue of vacating a record of conviction, vacating a juvenile conviction is also a creature of statute, meaning that the only right and remedy that exists is set forth specifically in that statute, RCW 13.50.050. And what I'd like to do is, instead of getting bogged down in too much detail, I'd like to talk just generally about the special issues that pertain in sealing juvenile records. First of all, there's a basic disqualification if it involves a sex crime or sex offense. Blake explained previously that there's certain kinds of felonies that are outside the realm of being able to vacate. And sex crimes in the juvenile arena are similar. If it's a sex offense, it may not be sealed, vacated or sealed under the juvenile records law. There's a couple of other requirements. There's some distinction between whether or not the juvenile conviction involves a Class A or a Class B or a Class C felony or a misdemeanor. Class A felony is, of course, the most serious. So the rule says if it's a Class A juvenile felony conviction the person must have 5 clear years in the community without any other convictions. If they've been been put in a juvenile detention facility after conviction, the time that they are incarcerated does not count. The time must be clear time living in the community. In the case of a Class A felony, it's got to be 5 years. That really is the key. Well, I would say that really is the key element. There are others, including if the original conviction included an order of restitution, that has to be paid off for the person to qualify. Restitution is, of course, the scenario where a person commits a crime, it causes some damage or causes some expense to someone, a victim is out money, and the court orders that in addition to serving a sentence or some other penalty, the person must pay restitution to the victim. And that is usually a compensatory monetary sum. And the statute basically says if there's been any order of restitution imposed, that has got to be paid off before there's going to be any vacating or sealing. In the case of a Class B or Class C felony or a misdemeanor, the main distinction in the case of a Class A felony, it's got to be 5 years. That really is the key. Well, I would say that really is the key element. There are others, including if the original conviction included an order of restitution, that has to be paid off for the person to qualify. Restitution is, of course, the scenario where a person commits a crime, it causes some damage or causes some expense to someone, a victim is out money, and the court orders that in addition to serving a sentence or some other penalty, the person must pay restitution to the victim. And that is usually a compensatory monetary sum. And the statute basically says if there's been any order of restitution imposed, that has got to be paid off before there's going to be any vacating or sealing. In the case of a Class B or Class C felony or a misdemeanor, the main distinction is instead of 5 years, it's 2 years. The person has to be living in the community with no further convictions or criminal charges pending for 2 years. They must have 2 clear years. They must pay any restitution that's been ordered. There can be no other criminal charges or cases pending. Now, one thing that I need to explain with regard to these juvenile records, and this is a little bit more complicated than in the adult scheme because the language under the statute is different. Remember, I warned you all at the very beginning that we can't mix and match words like sealing and vacating and expungement. It's a little more messy in the juvenile arena, partially because the statute basically says that if someone qualifies under the statute, their record is sealed, and it's as though the offense never occurred, which specifically means the person can answer the question, have you ever been convicted? They can say no. That's big distinction. But the trick with it is, the statute also says, but if there is a subsequent conviction of a felony, the juvenile record can be unsealed. So it's different, very different, in that, again, we're not talking about the actual destruction, the physical destruction of a court record. That is rarely going to happen unless there's a very special, specific order of the court. What we refer to in the juvenile arena is sealing the record or limiting or restricting access, coupled with giving that juvenile the right to deny any conviction. All of that goes away, though, if it turns out the person is subsequently charged with a felony or is charged with, or is convicted of another crime as a juvenile, or becomes an adult and is convicted of a felony. Then whatever happened as a juvenile, those records are unsealed and are available for public scrutiny. That was, well, a couple of other things I want to mention about this. One of the things that's interesting about this area of vacating and sealing and expunging is it's one area of the law where, for whatever reason, the state legislature and the state courts have put together a really good assortment of forms, pre-printed forms, and those are the ones that we've included in the materials. And I just wanted to make a note of it. As someone that does a lot of work in the civil arena, it's really, we don't have a lot of forms that we need. A lot of times people have to go to an attorney because there's nowhere to go to get a really good form, even if it's relatively simple. There are great forms that are available online that are printed and published and authorized by the state of Washington, courts and legislatures. And I personally think that someone can, if they take the time and are very careful and cautious, if they go through the forms very carefully, it is something they may be able to do on their own. I'm just hesitant to, I personally am a little hesitant to advise people to do that, just because I've seen people make very minor mistakes, get frustrated, go to court, there's one little thing wrong, and they're bounced out. So I'm very careful and cautious about, telling people they can just come up and fill out the forms themselves and go to court. But I understand that from questions that were posed before we started today, that there may be many situations, many people that don't really have a reasonable option. And if they're going to have any help, they're going to have to give it to themselves. And fortunately, there's a great set of forms in this area that people can use that are much better than what many of us lawyers have to deal with in other contexts. I think that what we should do now is move to this area of sealing. And again, just to help orient people right away, there's a big distinction between destroying a record and limiting access to it. And when we're talking about sealing a court record, it's not physical destruction of the record. It's limiting or restricting access to it so that general members of the public can't access to it and get into the details. What I'd like to do is now turn back to Blake and have him explain to us his view on what is sealing a court record, when is it advisable for someone to do it, or when is it a good idea for a lawyer to advise the client or potential client to seal the record, and how do you do it? What are the procedures for that?
Thanks.
Blake?
Well, first of all, let me now welcome you to what I would call the swamp of the CLE. This is the part where it's all muddy and there's actually a whole lot of bad answers in addition to a few good ones. And it's a terrible thing, particularly for a pro se, to start having to wade through. And I'm going to do my best to explain what's going on in this area of law and to try to tell you the sort of things that we can tell people as we're trying to guide them through this when they come into our clinics. First of all, sealing is really important, sealing records. Getting a conviction vacated but then not sealing the records means that potential employers and other people can still go to the court and take a look at these things and see, oh, well, it was vacated, but I can still see everything that happened. They pled guilty on this day, yada, yada, yada. It's awfully neat that under the vacating statute, our government or our state legislature has said, hey, you can lie. You are essentially, it says right in the statute that once it's vacated, you can tell an employer that you were never convicted of the crime. That's what the statute says. It's kind of an interesting thing to see right there codified. But sealing then takes the extra step of saying, okay, let's seal off this file so that if somebody tries to check, they can't see it. And there's procedures under General Rule 15, which I have printed for you towards the back of the materials, that talks about when and why you can seal. Juveniles can have their things sealed pursuant to 1350-050 that Nigel was talking about. Well, now we're starting to head into the bad part. There's two problems with this procedure. The first is that you can't unring a bell, and I was talking about this earlier. Once in this super information technological highway world that we live in now, once the information gets out there on the internet, it's virtually impossible to chase it down. There are people who are selling this information online, and those people don't want to stop selling it. And if you tell them that they need to stop selling this information because it's no longer true, these people aren't lawyers. And they're going to say, well, I'm not sure. It seems to me that it is true that these people were convicted of a crime, and I'm not sure why I should remove it from this website, and I think I'm providing a valuable service by putting this information out. It's really hard to chase this information down. And the pro se clients that we're going to have coming to us in our clinics and are not going to have the sort of money, not to mention time, to chase down every single person online who's putting this information out. So that's a real huge problem. It's also, this sort of information is also available on SCOMAS links, other directories that are linked to the court. But then we got a bigger problem. In 2009, the court, Washington State Court of Appeals in King County, or in Seattle Division I, issued a ruling entitled State v. Waldron. And State v. Waldron took a look at General Rule 15 in the context of somebody who had vacated a conviction and wanted to have their record sealed. And they accepted the prosecutor's position that General Rule 15 does not comply with our state constitution, which talks about open courts being available to everybody. They said, let's look at this, a decision, Seattle Times versus Ishikawa, that happened back in 1980. And that talks about sealing records as well. And let's see what they said. And Ishikawa came up with stands for 5 factors that a court is supposed to look at and balance and weigh before making a decision about whether or not to seal a record. Now, this is about 2/3 of the way through our package, and it's this page. It's got 5 paragraphs and a cite. And this is basically, I excerpted Waldron, which is quoting Ishikawa. And this is what Division I said should be looked at when somebody is seeking to seal a record. They should look not only at what General Rule 15 is asking for, but they should also look at the Ishikawa factors when considering whether or not to seal a record like this. It's still not able to get records sealed, but it's certainly much more difficult. And it kind of takes some lawyering. And if pro ses are coming in and asking for help, we're going to kind of have to teach them to make lawyer-like arguments. And we're going to have to go through these Ishikawa factors with them, and we're going to talk about how they apply to these people's lives. And we're going to do that by having comprehensive interviews where we talk to them about what's going on in their life, and we're going to figure out how to include it. Now, this is a new area of law. This is a mid-2009 decision. Things are developing here. There may be new attacks on this case, and there may be great ways to distinguish a Waldron-Ishikawa decision from this situation that our pro ses are coming in and asking us for help with. But here's my caution. There's a limited number of things that we can do when we're trying to help people who are coming in seeking volunteer help. And I don't think that we should try to attempt to teach these people how to try to make attempts to create new law or great arguments that they can march to the Court of Appeals. Because they need fast answers, they need to get their jobs, and they need to get their housing. So rather than talk about what's wrong with the Waldron decision, I'm going to propose to you a way to try to work with the current law And when we work with our pro se's who come in and ask for help like this, we're going to tell them this is not guaranteed. You should ask for your records to be sealed. You absolutely should. But you have to know there's a good chance that you're not going to succeed under the current statutory and case law scheme. So, again, I'm going to take you to the forms that that we've included in the packet, and I'm going to, about halfway through, we've got defendant's motion and order to seal the court file pursuant to General Rule 15.
No, if I could interrupt you just for a second. I probably should have set this up before I turn it over to you. I have been making all this emphasis about these certain laws are statutory creatures, they're purely statutory, et cetera, I may have forgotten to ask you specifically, is a motion to seal a court record, though, that's not made under statute, that's made under a rule, GR 15?
It's been under GR 15, absolutely.
Okay, and we have that in the materials, I think.
GR 15 is towards the end of the materials.
Okay, thank you.
All right.
Yes, I've got a question.
Oh, please.
I'm kind of confused the difference between vacated and sealed.
When a person, the question is, what's the difference between vacating and sealing? When a person goes through the procedure of having their conviction vacated, hopefully, if they're following all of the procedures, they know that they qualify, the appropriate amount of time has passed, they're seeking to have their most recent felony or conviction vacated, and the judge is going to say, you followed the conditions and terms, and I'm happy to grant this order of vacating. However, when a judge enters that order, he signs it and he puts it in the court file, and the court file gets filed again back in the clerk's office, and it doesn't go away. Somebody can come into court the next day and request to see that file, and the file will come out, and they will see that this person was charged on this date, this person was convicted on this date, and then they're going to see, 5-10 years later after they completed this, then they're going to see, oh, they received an order of discharge on this date, and then they're going to see 5-10 years later, they received an order vacating that conviction. So everything's going to be there. So that person who's the subject of that court file can march around, and they're allowed to say, yes, I was never convicted of that charge. By statute, they can say that. However, people can still go and access that file. So something that was routinely done before 2009 by people who do this sort of things is that a lawyer would say, hey, I'm moving to vacate. I also would like this court file sealed pursuant to GR 15. And if a judge would agree to vacate, he usually would go ahead and sign off on sealing as well. Things became much more complicated after Waldron.
If I could take just a moment, because I think that question is really important. I'd like to take a shot at it too. What Blake is saying is that someone is convicted of a crime, years later, they're able to have that conviction vacated.
Is that removed?
Well, this is what I'm going to try and explain for you. So the person goes into court, petitions the judge, will you vacate my conviction because I qualify for all these things? And the judge says, yes, you qualify, your judgment is vacated, I'm signing an order right here that says the conviction is vacated. Well, there's a court order, physical piece of paper that has the judge's signature on it. And that goes back into the person's file, and that goes back into the storeroom here in Pierce County. The Pierce County Superior and District and Municipal Courts maintain court records. And so in my scenario, there is a physical order saying the person was convicted on this date, but now the conviction is vacated, and that is sitting in a file somewhere. And in this day and age, it may be scanned and made into an electronic file. So what Blake is saying is, in that scenario, if someone were to ask you, have you been convicted of a crime, you could honestly say no, because the statute permits that if it's been vacated. But if someone went physically down to the Pierce County Superior Courthouse and pulled your records, they could pull out your file, and here it'll say, well, she was convicted of this crime, but I see it was vacated. But they have access, physical access to the material to the information. Hence the remedy of sealing, which is if the judge signs an order to seal the record, someone may go down to the Pierce County Courthouse and ask to see this individual's file, but if it's marked sealed, they can't even look at it. They can't even get to it. Normally, in the United States of America, all court records are considered public. This is public information. We all have a right to know. In order to seal a record and take it out of public view, you must have a judge determine that it's appropriate under the circumstances. And when we get into a criminal case, and this is what Blake's talking about, the Ishikawa case and the Waldron case, our state Supreme Court was grappling with criminal trials and criminal cases are open to the public, generally. Under what circumstances should those records be sealed? When does the individual right to privacy surpass or be more important or weighed more heavily than the general right of the public to know what's going on?
And I thought, kind of honestly, I want to get into the individual factors here.
So, hopefully that adds a little. I'm sorry for the interruption, but I thought that was pivotal. Blake, go for it.
I think that the reason that you got this question is that the intuitive thought is that once you get a vacate, you feel like maybe that means that this whole thing is going to go. You get a vacate, you feel like maybe that means that this whole thing is going to go away. But a vacate just means that an order has been signed,
So
allowing you to say certain things.
It's a step.
You need the additional sealing to actually make that go away. So let's talk about how to get to sealing, or how to attempt to get to sealing. First of all, in the materials, you're going to find the motion and motion for order, and then next you're going to find the declaration in support of the order. Now, here's what we should be doing. To comply with these 5 Ishikawa factors, which talk about how you weigh the public's interest against your client's interest, the first thing that we're going to do is we're going to sit down with these people and we're going to say, now, why is it that you want this done? They're going to, hey, it's simple. It's simple. I need to get a job. But we're going to try to pull from them some information. We're going to say, what are you worried about? And what has actually happened to you? And by pulling this sort of information out, we're going to have information that we can use to apply to these Ishikawa factors. Now, in the motion, this is a motion from Project Innocence. I've added some language. And if you're looking at defendant's motion for order to seal court file, that's the first page, the second page, the third page. At the bottom paragraph, I've added, Seattle Times versus Ishikawa sets out additional factors for the court to consider in evaluating whether to seal. The factors supporting that are: 1, is there a serious and imminent threat to an important interest? 2, is anyone present in the court must be given a chance to object to the sealing? 3, that there is not any way to protect the interest named in number 1, that's imminent, that's less severe than sealing. 4, the public's interest in the file is outweighed by the defendant's need for sealing. And 5, the period of time for this order sealing should be in effect. And then in the next page, I've said, here the Ishikawa factors are met because, and I've left 5 blanks. And then the next document is the defendant's declaration in support. And on the second page, under subsection I, it says, having the record of conviction has affected and continues to affect my professional and personal life, including opportunities for employment and housing in the following ways. In their declaration, they should be saying the sort of things that are Ishikawa factors. And in this form for the motion, you should be alleging those factors. You're going to get there by reading the Ishikawa factors that we just went through, and then I have them in more detail in the back on that one page, and then you're going to be expanding on them. Now I'm going to go ahead and give you my thought for 5 sort of things that you can say. And of course, you can't just write them in. You only can write them in if it's true for each defendant, for each person who's making the claim. But now I'm looking at the motion with all the blanks at the top. Under A, I'd say the defendant can be fired or lose their job or opportunity, or they cannot rent a home, they cannot go to the school program of their choice as a result of this file being open public knowledge. That's A. B, which says that anybody in court should have the opportunity to object. B, the prosecution has been served, the victim, if there was a victim, has been served, and everybody's aware of this, and everybody's going to be in court. C, talking about if we can find another way, saying I can't find another way to apply for my job, whatever, without sealing this old conviction. D, and D, I'm sorry, the factor of D is public interest is outweighed by the defendant's sealing. Well, this is an old conviction. This is a defendant who has served their time. They've satisfied the conditions of their sentence. They've paid their legal financial obligations, and it's been years since they've been convicted. So under D, we should be saying this is an old conviction. They paid their dues. They've lived a good life since. The public's interest in this old conviction has been diminished by the passage of time, and the need for this defendant's access to work is greater than this diminished former interest. And then E, which says that the period of time that you want this to apply for, I'd say something like, we're requesting that this order remains in place until the defendant no longer needs work or shelter. Now, I think that these are some arguments that we can make that judges will accept. Now, I'll tell you, Waldron, which imposes these Ishikawa factors, is a Division I opinion. Now, the last one that I did that I was talking about a month and a half ago, I went down to Thurston County Superior Court. The prosecutor did not raise Waldron. The judge did not raise Waldron. I made the motion to seal under GR 15, and the judge granted it right away with no argument. We had to wade through some other issues before we got to that. Waldron is a Division I decision. Division II, Division III have not so far fallen in place. Waldron went up to the Supreme Court, and the Supreme Court declined to review, so Waldron is good law and presumably can be followed anywhere in the state. However, if Division II could review and say, no, we don't think Ishikawa is appropriate, so there could still be a conflict. It's still worth trying to argue, and if you are in a different situation, you might not even want to bring up Ishikawa. But I think that we should be prepared for it. Another thing, in the defendant's declaration, then, you've alleged in the motion the 5 different things. Under subsection I, in defendant's declaration in support of sealing, you should say all those things. Again, finally, there is statutory authority that says that the order to seal, which is the 3rd document now in this little section, that there should be findings that are that support Ishikawa and GR 15. So I didn't put blanks in here, but it's possible that in order to get an effective order that complies with the statutory law, that the judge should interlineate, or somebody should interlineate that the judge found those 5 different things in the motion to be true in order to make that order effective. Here in Pierce County, we have a very aggressive and smart advisor to the sheriff's office, Craig Adams, who opposes these things all the time, and he assures me that he wins these things all the time. And he was kind enough to attach one of the motions that he uses to fight motions to seal, to send it to me to attach to my materials, and that's at the back of this brief. It's a district court misdemeanor where he's opposing conviction, and you might want to read through there to see the sort of arguments that he makes to oppose this sort of thing. But those are the sort of things that you need to do when you're making the motion to seal. If the seal is granted, then the court file will be done. At this point, you've got to. Oh, and by the way, if you're going to make the motion to seal, I talked about this after Nigel talked about juvenile convictions, because I wanted you to know that you can make the same sort of motion during juvenile convictions. You should file your motion and declaration to vacate with a motion and declaration to seal. And you should do the same thing with your juvenile proceedings. You should just file it with it at the same time so that it accompanies these procedures and they're all in front of the judge at the same time. So that's the way I think that we should approach the sealing. Questions?
So must you go through sealing the files before searching to actually destroy the files? I mean, because that's a possibility, isn't it?
Well, actually, destroying files is kind of different. Destroying files is something that's talked about in expungement. And there is no procedure for somebody who has received a vacatement of a conviction to have their file destroyed. They can only have it sealed. And they may only be able to have it sealed. Yes?
Now, when you talk about vacate, that's one conviction. What if they have multiple convictions? Can you apply for seal? Okay, no. So if you have one conviction and it gets granted, you can apply for sealing. That's
The truth is that you can apply to have anything sealed. And there was this huge series of articles in the Seattle Times about, I think 2 years ago, when they found that files were routinely being sealed, typically by attorneys who were involved in ugly divorces or ugly lawsuits, clients who were suing lawyers, and lawyers would go in and say, oh, Your Honor, now I'd like this file, now that I paid a settlement in this case, I don't want anybody to know about this, so I'd like this sealed. And the Seattle Times found numerous incidents of lawyers in particular, and the big target was an attorney named Brad Marshall. And they said there's all kinds of files that are getting sealed, and it just doesn't seem fair that lawyers who have special access to justice should be abusing this. But and I think that it's as a result of the attention that the Seattle Times brought to that and the actions that happened in our state Supreme Court and our state courts afterwards, that the prosecutors smelled a weakness in the system and decided to attack General Rule 15. But yes, you can apply to have anything sealed. There is, however, specific provisions under GR 15 and under the vacating statutes that seem to allow an open door to that. However, now by case law, those doors have been closed. So yeah, you could go back to other cases and apply that them to be sealed, but it's not going to happen. My practice experience is without some extremely interesting, unique detail, there's not a chance of that happening. Another?
You know, again, it's that conflict between, on the one hand, the courts acknowledging that there is a right of access, a public right of access to civil and criminal courts. We have the right to know what's going on in our community. We have the right to know, has someone been punished for this particular action? If so, what? At the same time, the courts balance that with, well, but there may be special circumstances where someone has a privacy right or some other critical factor that should outweigh the public right of access. And so I think what Blake is saying is, well, probably in most times, everyone should always move to seal a court record, because you don't want any old person to have access to personal information about your client if it can possibly be avoided. So probably looking into, can we seal the file or record, is a good idea. But Blake is also saying, but it's tough to do, because the Supreme Court here in the state of Washington has told all the judges in all the state, with this Ishikawa case and the Waldron case, don't be just routinely sealing files. It's contrary to public policy. There must be a very good reason to justify it in a particular case. And that is what Blake's been doing when he talked about the Ishikawa factors. Here are the things that someone would want to put into their motion if they're trying to say, I'm in the situation where it's appropriate for my rights of privacy and so on to outweigh public right of access. It's not easy to do, but probably something a lot of people should at least try to do, especially coupled with if they get a conviction vacated.
Absolutely. Sorry, you had a question?
Do you recommend for or against combining those motions and orders?
I recommend for combining. If you're doing the adult, combine it with either felony or misdemeanor, combine it. If you're doing the juvenile procedures, absolutely combine it.
Can I give you an example and ask you what you would do? Let's say somebody had a misdemeanor conviction of domestic violence 20 years ago, right? And then in the last 6 months they got a reckless driving.
You're already stopped. They're not going to be able to vacate domestic violence misdemeanor.
Okay.
Because it's one of the precluded crimes under the misdemeanors.
And they work in a nursing home. where a person has been law-abiding for 20 years. And
You can always try.
You can try.
But it's not going to go anywhere. The prosecutor's going to come back and say, hey, this is precluded from being vacated, and there's not a compelling interest. And as a matter of fact, if somebody's working in a nursing home, then the employer should maybe be able to know that this is somebody with a history of somebody close to them.
It should also be mentioned, though, specifically you talked about elderly people. One thing I should mention today is that there are some specific statutes, and I'm looking now at RCW 9.96A.060, that talks about employers that hire and employ people that are dealing with children or vulnerable persons may have a greater right of access and a greater right to inquire about convictions. So it gets a little bit beyond the scope of our seminar to talk about, you know, when an entity, an agency entity, or someone else may have a special right of access to criminal data. But what you're talking about is a very good point, because there are some exceptions in cases where there are vulnerable, either children or vulnerable elderly.
And I'm sorry, you have a question?
Yes. Say you were charged and the charges were dropped with prejudice. Would that be a problem of sealing the actual?
That is an excellent question. That's a great lead-in to what Nigel's going to talk about next. And Nigel, I'm going to caution you. We've got less than 10 minutes, and I want to introduce the law. We want to introduce the law club here.
Okay.
But Nigel's now going to talk about that.
Okay, that is actually a great question, and that will be the final section that we're talking about. And now we get back to the word expunging and expungement, which basically means an elimination, a removal, a physical destruction. And there is a special statute that relates specifically to expungement, and that's RCW 10.97.060. The critical thing to understand about this statute, about the expungement statute, is that it's not talking about criminal convictions. It's talking about non-conviction data only. For example, if someone is arrested and they are interviewed and they're under suspicion, but they're not charged with a crime and convicted of a crime, that's non-conviction data. And in the state of Washington, the statute, RCW 1097.060, allows someone specifically to petition for an order that orders Washington State Patrol or any other law enforcement agency that's holding the information to physically destroy the record. And this is very unique, very special to the expungement statute, in that it does allow for the physical destruction of information. You can only do it, though, in very special circumstances, and those special circumstances are non-conviction data, i.e. arrest, issuance of a warrant, issuance of a citation. There's got to be 2 years, passage of 2 years of time since either the person obtained a favorable disposition, and that could be acquittal if the crime was charged, or it could be dismissal. It's got to be 2 years since a favorable disposition by the court, or if there never is any court disposition, 3 years since the time of the arrest or the issuance of the citation. There are times when someone is arrested and told, we're going to file charges here for a crime, and for whatever reason, the prosecutor may examine the case and determine it doesn't have merit or they can't be proved. It never gets past the arrest stage. And that is what this statute is designed to deal with. If someone has non-conviction data, including arrest and related information, if the cases never pan out, well, if the person is either acquitted or the charge is dropped or no charges filed or for whatever reason never pan out, someone has the right to have that information deleted. if I may just finish, the primary repository of information that one is targeting is the Washington State Patrol, because they're the entity, the state that maintains a database. But the statute also, we have to remember that the way it works in the state of Washington, all over the state, you could be arrested, someone could be arrested by local city police, by the county sheriff, or by the Washington State Patrol. And if someone is arrested by city police, for example, the city police department may maintain a separate record. And this statute allows the individual to go not only to the state patrol, but to the individual agency that made the arrest or issued the warrant, and force them to physically destroy information, destroy that information. The other conditions, though, you know, as with everything else we've been talking about today, it's not open and available to everybody. I mentioned you've got to have this passage of time, whether it be 2 or 3 years. There also can be no prior felony or gross misdemeanor convictions. And there can be no arrest or charge pending in the interim. So it could be a great remedy for some people that don't like the idea of having charged with a crime and convicted of a crime. That's non-conviction data. And in the state of Washington, the statute, RCW 1097.060, allows someone specifically to petition for an order that orders the Washington State Patrol or any other law enforcement agency that's holding the information to physically destroy the record. And this is very unique, very special to the expungement statute, in that it does allow for the physical destruction of information. You can only do it, though, in very special circumstances, and those special circumstances are non-conviction data, i.e. arrest, issuance of a warrant, issuance of a citation. There's got to be 2 years, passage of 2 years of time since either the person obtained a favorable a favorable disposition, and that could be acquittal if the crime was charged, or it could be dismissal. It's got to be 2 years since a favorable disposition by the court, or if there never is any court disposition, 3 years since the time of the arrest or the issuance of the citation. There are times when someone is arrested and told, we're going to file charges here for a crime, and for whatever reason, the prosecutor may examine the case and determine it doesn't have merit or they can't be proved. It never gets past the arrest stage. And that is what this statute is designed to deal with. If someone has non-conviction data, including arrest and related information, if the cases never pan out, well, if the person is either acquitted or the charge is dropped or no charges filed or for whatever reason never pan out, someone has the right to have that information deleted. If I may just finish, the primary repository of information that one is targeting is the Washington State Patrol, because they're the entity, the state that maintains a database. But the statute also, we have to remember that the way it works in the state of Washington, all over the state, you could be arrested, someone could be arrested by local city police, by the county sheriff, or by the Washington State Patrol. And if someone is arrested by city police, for example, the city police department may maintain a separate record. And this statute allows the individual to go not only to the state patrol, but to the individual agency that made the arrest or issued the warrant, and force them to physically destroy information, destroy that information. The other conditions, though, you know, as with everything else we've been talking about today, it's not open and available to everybody. I mentioned you've got to have this passage of time, whether it be 2 or 3 years. There also can be no prior felony or gross misdemeanor convictions. And there can be no arrest or charge pending in the interim. So it could be a great remedy for some people that don't like the idea of having their photograph or fingerprints on file somewhere. It could be a great remedy for that. But it's not going to be available to someone that's been convicted of even a gross misdemeanor. Yes?
Does everything you just outlined include charges dropped with prejudice?
If charges are dropped with or without prejudice, I think they're gonna a dismissal of charges with prejudice, in my opinion, is marginally better than an outright dismissal, because a dismissal with prejudice means they can never ever be refiled. So that's better if that's your client and that person has a dismissal with prejudice. That's better. But just so that you know, under the statute, that distinction is not made. The statute says if someone is arrested or cited or a warrant is issued, if the agency, if law enforcement does not act on that within 3 years, it's gone. It can be eliminated. And they don't make that distinction between with prejudice or without. The distinction is if it's actually dismissed by the court, you only have to wait 2 years. If there's been no court action, it's just sitting out there, you have to wait 3 years. Yes, I would like to do just one thing though, and that is that Blake mentioned that we had in our materials a very interesting brief that was prepared by attorney Craig Adams, who works as legal advisor to the local sheriff's department. This is really a very interesting read that may help explain some of the things we're talking about, because in this brief, they are definitely arguing that there's a big difference between sealing a record and expunging or destroying a record. And in this brief that's in the materials, they're actually talking about a case where someone had criminal charges dismissed against them. They were dismissed, and they came back later and said, I want these records destroyed. I want these records destroyed because the charges were dismissed. And the argument that I think was made successfully by the prosecutor's office is, no, there's no authority to destroy a court record. If someone went to court and they were charged and then the charges were dismissed, that is a court record that exists that will be put back in storage. Maybe no one will ever look at it, but it's going to sit there. We're not going to destroy it. And the argument was made, if they wanted to seal that record, if they wanted to seal it, they have to go through the GR-15, the GR-15 Ishikawa analysis that Blake was talking about. So this memorandum, I'm glad Blake was able to get this memo, and I think it might well be worth the time for you to look at it, because it gives the argument about the big difference between sealing and physically destroying a record, and how there is no way to physically destroy a record unless it qualifies for expungement under RCW 1097, or someone gets a special order under GR-15 that maybe even goes past just sealing. In any event, I think we have covered the subject areas we were planning to. We did want to, invite any other questions. We'll stay here as long as people have questions. We thank you very much for your time, and it's been an honor to be here.
And I'd like to thank Linda Black, who's our coordinator, who's put this whole thing on for us. And also, Corbin Scott is over here, and the whole team over here on my right is the clinics. And that's right here, I understand, and I think that's a noble cause. I think it's incredibly valuable. Anything else you want to add?
I guess we would just ask if there are any other questions.
Well, thank you all for coming. Anybody who needs to get out, the CLE ended 2 minutes ago.
question.
Yes.
So now, assuming a conviction does get vacated, does it, when you do a standard background check for, say, employment or whatnot, will just absolutely nothing show up, or will it show up as conviction vacated?
You know what? Unfortunately, if they get their conviction vacated and nothing else, no seal, then if somebody goes on links, they're going to see this whole court file. And they're going to see single line entries for everything. They're going to say affidavit of probable cause. Somewhere down the line, they might see a judgment and sentence, and then they might see the filing of a certificate of discharge, and then they might see 5-10 years later, they might see an entry for a motion in order to vacate, and then an order granting that.
Okay.
If they're an attorney, then they're going to be able to click on the hyperlinks for each one of those, and they're going to be able to read the documents that are going to describe what the person was charged with, and they're going to see, possibly they're going to see the statement of defendant on plea of guilt, horrible things like that. So no, unfortunately, all the order in a vacate does really is give the person a right to say that they were ever convicted. But it doesn't mean that somebody can't go and open up that file either online or even physically walking into the courthouse and opening it up. To get that second sort of relief, you need to seek a order sealing the file.
We talked about the juvenile vacating and the adult vacating, and we did mention that the adult vacation can only be done once in a lifetime. If they had a juvenile record vacated, is that going to make it so they can't get the adult one, or is it separate?
I have not run into that situation. I would think that would preclude it. For one, you know, when they get the juvenile thing vacated, they have to say there's no subsequent stuff. If they had their vacation done 10 years ago, and then 20 years after that they run into their problems, it's possible that they could sneak it through. I think that the prosecutor is probably going to cite the statute and say, hey, they've already had one vacation and we're opposed to them having a second.
It seemed like there were different factors that considered in the juvenile and the adult one, so that could be an argument too.
Could be an argument.
All right, thank you.
Sure. Valerie.
I'm sorry if I missed this when you talked about it, but so if you have a client who, say they're charged with multiple crimes and it's domestic violence, turns out totally bogus charges, somebody lied, they find out, they dismiss the charges. Now, still every time somebody accesses that records, they see that they were still charged with those domestic violence crimes. Would that be, can you deal with that through expungement?
Yeah, that's not a vacatement scenario. That's an expungement scenario. And yeah, you can, oh, hold on. There's no provision against DV and expungement. Yeah, I don't think so. Yeah, I think there are certain statutory provisions, waiting periods under expungement, and as long as they wait long enough, they might have to wait 3 years. Unfortunately, you can't just go into court the next day after it got dismissed and say, hey, I'd like it vacated now. You got to wait the time period, but then you can seek expungement.
And that would be 2 years for...
But see, I also think, though, that the message I got from reading Craig Adams' memorandum of law is that the local prosecutor takes the position in your scenario, if the charges were deemed had no merit and have been dismissed, the position taken by the prosecutor's office is that those records still cannot be destroyed. The court records cannot be destroyed. If the person was arrested, their arrest data may be purged, destroyed, forced to be destroyed. That's in the hands of the county sheriff or the police department. But they're making a big deal out of, but not the court record. There is no statutory provision for destroying a court record other than possibly GR 15. So in your scenario, the expungement only relates to non-conviction data in a law enforcement agency possession, not in a court file or in a court record.
So, if I'm understanding you correctly, so if somebody goes and runs my client's criminal history, that's going to come up. So even though it's been dismissed, they're still going to have access to it.
If Craig Adams wins the fight when you go to court.
And I think one of the things, it's my impression in discussing these matters with Blake that, you know, you can see a variation in how different counties handle it. It just so happened that, Mr. Adams here was very forthright and very willing to give us his material and state his position. And his position is, there's a big difference between destroying material in a court record and destroying material that exists in a law enforcement agency's files. He says they're completely different, and the expungement statute does not apply to court records. That's got to be GR 15.
So then would you be able to seal it, then at least so that people wouldn't have access to it?
I think that's certainly under, you can make the motion under GR 15.
Would you succeed?
Not guaranteed, but I think that certainly there's compelling reasons. And if you're going under GR 15, and I would argue under the Ishikawa factors as well, I think judges would be persuaded. And when you make the argument, you got to make those humanistic arguments that that we lawyers know how to bring forward. And maybe you're going to get a judge who's very sympathetic. Certainly, judges are still sealing records after Waldron. And this strikes me as a sort of circumstance where a judge might be sympathetic.
So following up on that other question that I had about somebody that had a 20-year gap between the
DB and a reckless.
Yeah. And so if you bring the GR 15 motion, do you have declarations from place of work, declarations from maybe the victim saying,
It wouldn't hurt.
It wouldn't hurt. Okay, so
it's not statutorily called for, but it would certainly help. One thing that the judges always want to know is, has the victim been notified of this proceeding? And if you're attaching a declaration from the victim, then the judge is going to certainly be all the more interested in what the victim has to say.
So that's the only place where the judge has discretion is the GR 15?
Well, yeah, under GR 15 and the Ishikawa factors, the judge has a lot of discretion.
Can you apply for more than one sealant if you don't succeed the first time? Perhaps by maybe a different judge, or?
Yeah, you can certainly. The thing about sealing is it's kind of like suing people. You can sue as many people as you want. Dale Washington will tell you that. You can apply for as many sealings of records as you want, and it's just that there's provision under the vacatement session or in GR 15 that contemplates people getting a vacatement. So certainly you can try.
I think my own answer to that would be, generally, if you make a motion and you lose, you do have a right to make a motion for reconsideration. And sometimes if you think the judge really overlooked something and that if you just represent it slightly differently, you'll get a different result, you can do that. It's just that the more and more motions for reconsideration you file, sometimes the more irritated the judge gets. If they think they've already heard it all and made a decision, unless you can point to a change of circumstance or something that was glaringly omitted by mistake, you got to be careful about repeating the same things. And that's just not motion to vacate. That would be any more motion in any court.
I'm sorry to interrupt. I just want to say they want us to hurry up and wrap it up and relinquish the room.
To vacate the room?
Yes, vacate.
Is that a motion?
One of the most interesting areas in this evolving area of law right now is something that Mr. Krisnock brought up earlier, and that's a situation where your client has been found not guilty. They were never convicted. But in that case, your client was originally charged with a crime, and it was a stipulated order of and they reached a resolution through something called a stipulated order of continuance or continuance without finding. And then you send notice to the Washington State Patrol that you'd like them to expunge because your client was not found guilty. And what Mr. Krisnock found, and what Mr. Adams argues in court, is that they argue that this was not really a dismissal. This person wasn't really innocent. And if you look at the requirements for expungement, which is the second page, if you look at the Washington State Patrol application, it talks about 1097 in section 1. It says that you're not eligible for expungement if the disposition was a deferred prosecution or similar diversion. So the Craig Adams, Washington State Patrol, are taking the position that continuances without findings, stipulated orders of continuance, and I'm sure court sentences are similar. Pardon me?
What you said yesterday was if they had any conditions, so you had to pay costs, or you had to go, say, do an evaluation, or something of that sort, keep your nose clean, that's enough not to let them do anything.
And here Mr. Krisnock is looking at a client who has been found not guilty. They have a court order that shows that they're not guilty, and still he's running into this wall. Well, you know,
Dismissed, and I've been trying to find some way to get rid of the record for compliance.
Your theory, your theory, your theory, your theory, your theory, your theory. Hit me. Your theory, your theory, your theory, your theory, your theory. Hit me. Your theory, your theory, your theory, your theory, your theory. Hit me. Your theory, your theory, your theory, your theory, your theory. Hit me. Your theory, your theory, your theory. Your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. Your theory, your theory, your theory, your theory, your theory, hit me. And that's what's left.
Everybody in the business is a criminal. And how can you ever trust a criminal?
Black Bolt, don't do it!